before you today, humble servants of this state and of you, dear God. We ask you to bestow upon us just a measure of your intelligence to help us make good decisions for our employees, for the citizens that come before us today, for the citizens of this great state. And when decisions don't go our way, please give us a measure of grace to accept it with your solitude, and we ask this in your holy name. Amen.
It is now 8:38, and the meeting of the Commission of Licensing Regulation will begin. Ms. Mahon, will you call roll, please?
Mike Mendez.
Present.
Tom Butler.
Here.
Ray Callis is absent today. Helen Callier is absent today. Rick Figueroa.
Here.
Gary Wesson.
Here.
Deborah Yurko is absent today.
We want to take this time to welcome our new commissioner, Gary Wesson. He's actually a doctor. He's a dentist. Orthodontist. So I've taken the liberty of calling him Commissioner Dr. Wesson. Kind of break him in for us. So, but we do want to welcome you to the commission, his first meeting. So we also have another individual that's been appointed, Dr. Ray Callis, who has unfortunately not been able to make an orientation, which is a requirement before anyone begins a stint on a board or commission. So he will be at our May meeting, and you'll be able to meet him then. So for those of you that won't be here in May, it's a good reason to come back. So, but you'll see him then, and we're also going to recognize the outgoing commissioners that we've had that were leaving and provided service to this agency. So we'll do that in our May meeting. I want to open up right now for public comment. I believe I have an Alfred Green. Are you here? Come on up. We're going to go ahead and let you do your public comment since it looks like you're from Houston. You probably want to get back. So, I'm sorry, just have a seat. Yeah, we'll catch you on video. So, if you don't mind, state your name for the record.
Alfred Green.
You've got 3 minutes, Mr. Green, to let us know whatever you want to let us know.
Okay. Well, I've been having licenses for some time back during the Carter time. And one of the things that I've always been pushing for is to keep it where we have someone in the classroom and not just throw it on the internet and let that be it. I don't think the client get the same help, and that's basically my comment.
Mr. Green, what kind of license do you have?
Well, I have the DWI education, the DOEP, and the kids.
Okay.
Driver's education.
If you don't mind, we need you to sign this right quick.
Okay.
It's just, so you're what you're saying, Mr. Green, is you're advocating that there be in-room classroom time.
Correct, as we're doing it now, and and not
Just a moment,
throw
Mr.
it
Green.
on.
Commissioners, because of the fact that this was, Mr. Green has come before us, and we did not have posting the agenda simply as a public comment, we are not allowed to be able to ask questions back to Mr. Green.
I apologize.
So, Mr. Green, if you don't mind just signing this, we need to get your signature on this. And my apologies, but if you had let us know that you were going to be here, we put on the agenda, we would have been able to ask all sorts of questions.
7:30. I thought it was going to be at 7:30.
Yeah, well, I try to get these guys here, but they wouldn't come.
Out of order. You should have put me on the side.
Thank you, sir. Appreciate it. Thank you for your time. We'll now go on to item E, executive session consultation with Commission's attorney pursuant to 5510711 of the Government Code. A briefing from legal counsel concerning pending or contemplated litigation. Advice from the Commission's attorney on legal matters authorized by Section 5510712 and under Section 5510774 of the Government Code. Discussion of personnel matters related to executive director. We'll now go into executive session. is 9:15. Commission will come back into order. I don't believe there's any action to take out of executive session, so we'll bypass item F. Commissioners, I would go back to the item C, certification of quorum. We normally will accept an excuse for the missing commissioners, which in this case are Commissioner Callis, Commissioner Collier, and Commissioner Yurko. So if you're so inclined to accept their excuse, I'll entertain a motion.
So moved.
Second.
A motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. All right, let's move on to item G, approval of the minutes. You've had the minutes that were submitted to you. You've had the opportunity to review those minutes. A motion would be in order to accept the minutes from our previous meeting.
So moved.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. All right, let's get on to our cases. Item H1, Black Bull Towing. Mr. Shirk. Go ahead and have a seat.
Thank you.
Chairman
Proceed.
Harris Mendez, Commissioners, good morning.
Morning.
Dr. Wesson, I want to thank you for your public service and being on the commission. My name is Michael Shirk. I'm one of the prosecutors with the tow team. This case comes before the commission on a proposal for decision issued in October 20th, 2017. The parties, that is staff and respondent, are requesting that the commission modify the proposal for decision to reflect the terms of a compromise and settlement agreement, which I believe you have seen or have copies of. I'm prepared to talk about the compromise settlement agreement and how it altered the proposal for decision if you'd like me to. If you've already seen the compromise settlement agreement and have decided what you'd like to do, I can cut my argument short.
We have before us a compromise agreement, and if the commissioners are so inclined, we can just pass on this and refer it back to the executive director. We do have somebody here representing Black Bull Towing. In light of what was just mentioned, I don't know if you want to say anything or not. So I'm going to leave it up to you.
Just good morning, Commissioners. Thank you for your time, and no further comment.
Commissioners, we have a recommendation by the enforcement to go ahead and just pass on this item. If you're okay with that, then I'm just going to refer it back to staff, and they will work with Black Bull Towing on the agreement and get it to the executive director. So if you're okay with that, we'll bypass it. If there's any objection to it, let me know, and we'll proceed with the case. Okay, there you go. You're good to go.
Thank you.
All right. I'm just going to mark through saying that you did not testify before us today. All right? All right, let's go into item H2, which is on-site towing. Mr. Shirk, proceed.
This case involves a non-consent tow of two vehicles. The tows in each case were based on the vehicle owners violating parking rules of the apartment complex. One vehicle was backed into a parking space, and one vehicle was parked in such a way as to cross the painted line separating one parking space from another, often called double parking. However, as established by the Commission in a 2016 final order involving another tow company, these are not authorized reasons to perform the non-consent tow of a vehicle. In a proposal for decision dated April 13, 2017, the administrative law judge found that there were no legal violations that were proven by staff. One reason for this was because the Texas Towing Act, Section 2308.253, only addresses the illegal tow of unauthorized vehicles. The vehicles in this case were authorized to be on the parking facility. One was a tenant, the other was a visitor who displayed a visitor pass. Staff does not contest this conclusion since Occupations Code 2308.253B is, by its language, limited to the tow of unauthorized vehicles. I've posted the language of the statutes because we're going to get into some of the language. I know your eyes gloss over when I just throw around the citations without the language itself. And I need to correct myself. The judge found that there was no violation because Chapter 2308-255B, by its terms, prohibits the unauthorized parking of vehicles, the towing of vehicles. 255B, by its terms, prohibits the illegal towing of unauthorized vehicles. These vehicles were authorized to be in the parking space, so we don't challenge the administrative law judge's finding that there was no violation of 2308-255B. However, the administrative law judge went on to find that there was no violation of Texas Occupations Code 2308.253B 1 through 6. That's posted now on the board. Chapter 2308.253B6 of the Act contains prohibitions against a vehicle owner leaving a vehicle unattended. The provision relevant to this case, Section 2308-253B 1 through 6, which is posted on the board now, is specifically titled Unattended Vehicles on Parking Facility of Apartment Complex, Removal and Storage of Vehicles. This section of the Towing Act prohibits a vehicle owner from leaving a vehicle parked, or in the language of the statute, unattended, in 6 specific circumstances, which are listed there and include such things as obstruction of a gate or of a parking space reserved for disabled drivers, if the vehicle is leaking fluid that presents a danger or is in a towaway zone. But relevant to the case before us and the Commission's order in an earlier case, there are 6 specific reasons that a vehicle can be towed for parking in an apartment complex if it is authorized to be there. The administrative law judge found that this provision, that is 2308-253B 1 through 6, was inapplicable to the facts of this case. The first basis for this conclusion was because the section 2308-253 refers to private vehicle owners and not tow truck operators. If you look at the statute at the top, it says a vehicle owner may not leave unattended a vehicle that does one of these 6 things. She found that that was a directive to vehicle owners rather than tow truck operators. The second basis was because the vehicles were not parked in violation of the 6 instances when towing of authorized vehicles is permitted. Rules of statutory interpretation require the Commission read the Tow Act so that the entire statute is effective, that the object sought to be achieved is achieved, and that a just and reasonable outcome occurs. Clearly, in enacting the law, specifically 2308-253B, the legislature's purpose was to regulate the towing and booting of vehicles and not to regulate private behavior. The prohibition against leaving a vehicle unattended under certain circumstances can only sensibly be read in the context of what the Towing Act permits or prohibits of towing companies. By listing prohibitions against specific instances of unattended or parked vehicles, the legislature made it clear when tows of authorized vehicles could take place. The administrative law judge erred as a matter of law in finding that 2308.253B 1 through 6 inapplicable to the facts of this case. She also found that neither of the vehicles in this case fell into the listing of 2308.253B 1 through 6, and that's true. One vehicle was towed because it was double parked, one vehicle was towed because it was backed into the parking space. What that means is that the vehicles were not within that specific enumeration of 6 items for which an authorized vehicle could be towed. So that her finding, not contested by staff, that the vehicles were not in 253 1 through 6, supports staff's position that the vehicles were towed without legal authority. As you know, the Commission has already issued a final order. This was issued in December 2016, holding that an authorized vehicle can only be towed for one of the specific reasons given in the statute there. The administrative law judge held that because 2308.253 is within subchapter F of the Towing Act, and subchapter F of the Towing Act is titled Unauthorized Vehicles, the Department lacks jurisdiction to prosecute the illegal tow of vehicles which are permitted to be on a parking lot. This ignores the legislature's purposeful use of the word unattended in sections of the Act rather than its use of the word unauthorized. The legislature clearly meant to distinguish between different classes of vehicles when it talked about unattended vehicles as opposed to unauthorized vehicles. The Texas Code Construction Act resolves this dispute. It's very clear on this point that the heading of a subchapter does not limit or expand upon the meaning of a statute. Therefore, the judge's reliance upon the heading of subchapter F as unauthorized vehicles is legal error for the holding that she issued in this case. The administrative law judge also erred in holding that the Towing Act only addresses non-consent tows of unauthorized vehicles, that is, vehicles parked at a facility without the owner's consent. Taken to its illogical conclusion, this means that if each of your vehicles was towed during this morning's meeting, there is no authority for the department to take enforcement action against the towing of your vehicles. Whereas if somebody came to this parking lot and parked illegally, say they parked and went over and left the premises, or they had no business here, and they were towed, we would have jurisdiction to prosecute that case. This subverts a consumer protection mandate which shapes and informs every aspect of the department's prosecutorial model. Finally, the administrative law judge found that Texas Property Code section 92.0131 allows landlords, quote, to impose vehicle towing or parking rules or policies, end quote, for which it may then choose to tow vehicles. Of course, the Commission has rejected this argument in the past. The reason for this was because the Commission found that the Property Code is a procedural statute, not a substantive statute. The Property Code merely states that if a landlord has vehicle towing or parking rules or policies, it must provide a copy of those policies to tenants. The Property Code gives no authority to property owners to develop a code for towing vehicles which exceeds the limitations of the Occupations Code, the Texas Towing and Booting Act. A landlord may not direct and a tow company may not perform a non-consent tow of an authorized vehicle from an apartment complex except for one of the specific reasons in 2308-253B 1 through 6. The Commission has already ruled on this. What's surprising is that the administrative law judge was well aware of the Commission's decision at the time of her proposal for decision in 2017. Staff requests that the Commission not adopt so much of the proposal for decision which finds the Towing Act only applies to unauthorized vehicles, but find instead that Chapter 2308.251 and 2308.253 apply to the tow of vehicles otherwise permitted to be parked where they are. This will require a modification of conclusion of law number 8, which presently states, quote, the evidence fails to show that respondent violated Texas Occupations Code 2308-253, 2308-255B. Under an appropriate legal analysis, conclusion of law number 8 should state that the evidence fails to show that respondent violated Texas Occupations Code 2308.255B, but does show that respondent violated Texas Occupations Code 2308-253, which of course governs the tow of vehicles authorized to be on a parking facility. Conclusion of law number 9 should also be changed. It presently states that respondent is not subject to an administrative penalty or other sanction because no violation was proved. This conclusion of the law results from her erroneous conclusion that the department has no jurisdiction over tows of cars which are authorized to be in a parking facility. Staff requests that conclusion of law number 9 be replaced with language stating that respondent is subject to first-time Class F violations of $2,000 for each of the 2 illegal tows which occurred in this case for a total administrative penalty of $4,000. And I'm happy to answer any questions you may have.
Any questions for Mr. Shirk? Jonathan Bruce.
Yes.
I believe you're here on behalf of On-Site Towing. So if you don't mind, just state your name for the record.
It's Jonathan Bruce. I'm the attorney for On-Site Towing.
Proceed.
We simply just disagree with staff's position and believe the decision was correct. Essentially, before the first element of any of these towing cases is that you have to prove, staff had the duty to prove that the vehicle was parked at the parking facility unauthorized, without the parking facility's consent or authorization. Staff failed to do that. With respect to this ongoing issue for in the Black Bull towing case, and it goes on in other cases, about when you can tow a car from a apartment complex, if you take staff's interpretation of the statute, that means people can park cross the line, take up 5 spaces without, and there's no way to tow them off. All the parking permits that apartment complexes issue are worthless. They can park in reserved spots, and they cannot be towed. Obviously, with property owners and apartment owners should have the right to set their own towing rules for people they authorize to park there. Yes, those 5, people, those are a bare minimum where you can't park. But in staff's interpretation is that's the only reason you can tow from an apartment complex. Somebody's blocking your car in, sorry, can't tow it out of there. Property owners, apartment complexes should have the right to regulate parking and for people they authorize to park there. And that's why, if you want to read the statute, the legislator put the word unauthorized people or unauthorized vehicles. That's why it's in there. That's the threshold.
Is your argument that the individual that had a visitor's pass was unauthorized?
No, they're authorized to
So
park
they're
there.
authorized to park there,
Correct.
but yet they were towed.
They were towed because they didn't follow the parking rules. You can still, you're authorized to park on the facility. Yes, you're, as the person who was double parked was a resident there, and certainly
So
was.
is the statute for unauthorized parking based on what the statute states, or is it because of the fact that they didn't follow the apartment rules?
They don't follow the apartment rules.
But that's, what we're after here is the fact that if it was unauthorized or authorized.
Exactly, but they're authorized to, the threshold is, for the code to apply is, they have to show the person parked was not there with authorization from the property owner, the apartment complex.
But they were there with authorization.
Yes. And so at that point on, then you
So
have
they're
to.
subject to the rules at that point in time, is what you're saying?
Exactly. The rules of the apartment complex.
Okay.
And you still have, for a non-consent tow, you still have to have the signs and stuff, but it's just, you can't limit it down to these issues. Clearly, the state legislature did not say, well, you pretty much can park wherever you want at an apartment complex with no consequences.
Well, I don't think that was the intent.
No, but the result that staff is arguing for, that's the result, is that you can only tow away for these 6 enumerated items, which actually apply to say where the person can't park, not where you can tow from.
Mr. Bruce, you would agree, though, that if we didn't limit it to these items that are enumerated in law, that tow trucks could pretty much tow anybody and then justify it after the fact, don't you think? Either you parked head-in when you weren't supposed to park head-in, or you crossed the line, or you parked on the line. I mean, wouldn't it be kind of confusing at that point and almost a blank check for people to be able to tow and then justify it after the fact?
The code still requires notices to be placed at the entrance, and that's what, there was no question those notices, the signage was placed there.
Was it the proper signage based on statute?
Yes.
So there wasn't any signage that says do not park in backwards?
They had no head-in parking. Yes, there was a sign up that said no head-in parking.
What about double park? Was there a sign about double park?
There was not, no, I can't, but at some point, we
I
all
think
drive,
that's
we all
our
know
point.
you don't.
Yeah, there's the penalty of taking somebody's property in the state of Texas is severe, right? And that's a very big privilege or
Correct.
responsibility, in my opinion, right? Because that's, and especially their vehicle.
Right.
I mean, and so I think the barrier for that has to be fairly high.
My response is that the person who double parks is taking the apartment's property. If you're paying for a reserve spot in an apartment complex, you're paying your $20 every month or whatever, $50 to park there, and you arrive and somebody's in your spot. Under staff's interpretation, there's nothing you can do about it.
Shouldn't you take that up with the apartment complex and say, I'm not paying this month because somebody parked too close to my spot?
Or revoke their permit?
Isn't that a civil kind of a thing where you can take it up with them and maybe not pay or work something out with the apartment
But
complex?
your remedy, if you're paying, I mean, what if let's assume you know who's paying, the apartment complex says, well, we can't enforce that then. What's their enforcement mechanism?
I
To
understand,
revoke the permit.
but
Well-
the flip side is, the enforcement mechanism is the state of Texas is licenses somebody to go take your property.
I understand, but.
And that's a pretty severe remedy. I mean, that's, in the old days, that's kind of horse theft, right? And they'd hang a man for that.
Let me go, this is twofold. You said, if the visitor's in your spot, there is no permit to take. if it's a different person every night in your spot.
Do they have visitor parking?
As a practical matter, yes, most apartment complexes around the state are going to have visitor parking, designated visitor areas.
I think the other challenge, though, is you've got property code versus vocational,
I understand.
two distinctions. We're not in property business.
No.
Right, so.
But on the other hand, though, is the code is not only meant to protect the driving public, but also that preventing, property owners' rights too, in the sense that says, yes, here's where you can tow people's off for, because your property's being used. When apartment complexes are built, or any parking facility, it's based on how many residents we have, how much parking do we need? And under staff's interpretation, there is no way to enforce that at this point. I'm not saying they don't have to put up the signs, but to limit it to these reasons is that there's no reason to have permit parking in apartments anymore. Because there's no enforcement mechanism. And generally where you have the problem is visitors who come in and park in spots. Let's just say they don't have a reserved spot, they just have general permit parking. How do they enforce that?
I think you make good arguments, and I sympathize with some of them, but I just don't think that we have jurisdiction over some of those issues. Ours is very limited.
And I agree with you, but the rules of statutory interpretation dictate that you cannot read a statute to come out with an unintended result. And the first threshold that the staff needs to cross in this case, and they didn't, was to say that these vehicles were unauthorized. And that's the first element. And we just go back on the evidence presented at the hearing. There was never any evidence presented at the hearing to say that these were unauthorized vehicles. Okay. And so that's the first element. So if you don't get past that element there, the rest of it doesn't matter, as far as this decision goes.
Well, I think that my challenge is that we're talking about state of Texas residents' property as a vehicle is very, to take that barrier has to be, subjectivity can go either way. And to your point, right, when a property owner puts their property out to be leased or rented and out to the public to be parked, right, there's consequences, and that's property code, I think should handle it. But the subjectivity to allow, somebody to take the property of a citizen of the state is very, the barrier of that should be high, and I just don't see that in this argument right now because of what the legislature has put out. So,
If I may respond, there is a remedy for the vehicle owner. It's called a tow hearing. And I literally do about 600 tow hearings a year. And the threat in that is that attorney's fees are awarded can be awarded in those hearings. So there is a remedy. If they improperly took your car for $30, you can file for a tow hearing and have it within 10 days. There is a remedy for that.
Is that a local jurisdiction?
Local jurisdiction. They're in JP Court in Houston.
So,
We do them, I literally do them every week.
well, I don't argue that. I'm not
Yeah.
saying that's a good mechanism to put in place.
Yeah.
I think it's still kind of delving away from what we have to consider here.
And I understand that, but you have to read the code in its entirety. And again, the threshold question is that an unauthorized or authorized vehicle? If it's authorized to be on the property, then the code provisions staff is talking about just don't apply. That's the first element. It may be a harsh element, but that's the first element. There are remedies out there for vehicle owners, for tow truck companies who ignore notice requirements. And I represent 90% of my practice is representing tow truck companies. I can tell you, people are not afraid to sue. But that was the first element in this case. And even if you say staff is correct, that they still never presented any evidence at the hearing that these vehicles were unauthorized.
Any questions for Mr. Bruce?
You did a good job representing your.
Thank you. Thank you all. Thanks for being.
Mr. Shirk, nothing else for us?
No, Mr. Chairman.
Go ahead and have a seat if you don't mind. I'll go ahead and open it up for discussion with the commissioners, or a motion to be in order.
I make a motion that we modify the PFD. And specifically, I'd like to address conclusions of law number 8, number 9, and number 10. To state the evidence fails to show that respondent violated Occupations Code, Texas Occupations Code 2308.255 in TDLR numbers TOW 201-400-05271 or TOW 201-400-20797. Now, conclusion of law number 9. The evidence supports a finding that respondent violated Texas Occupations Code 2308.253 in the same TDLR numbers. And conclusion of law number 10, we're authorized to make changes subject to sections 2001.058 of the Texas Government Code.
We have a motion on the floor. I am going to ask a clarifying question. There was the enforcement team was seeking a $2,000 fine per violation. You haven't said anything about the fine. I don't know if you want to simply find that they were wrong and not have a fine, or if you're interested in a fine in it.
You know, I would seek some input from the commission on that.
So we have a motion on the floor. Let's go and get a second. We
We had
can
a
amend
second.
it and amend it. Okay, we have a second, Commissioner Figueroa. I go back to the original discussion I just had about the fine now itself. At this point in time, we simply have a motion to find that they were in violation, and that's it. I'm not sure if the commissioners want to leave it there, we can proceed forward without having a fine, or if you're interested in a fine, we need to address that issue also, because there was a fine that was sought out by the prosecution. It was $2,000 per violation for a total of $4,000.
Correct.
Sheriff, what do you think?
You know, I understand the argument, and I understand the ambiguity that can play on either way. I mean, my contention is that we have to be very mindful of what property owners have, right? And that's such a, and so the precedent's been set, and we need to, I think we need to honor that. I'm not sure there's a malice in it. I don't think I see that. So, and then for the penal action for this to be severe, it'd be pretty tough. So, I'd be open to cutting that back, if not removing it.
So, my original motion had no penalty. I think I'd just like to forward that motion, if that's okay.
I got no problem.
So we have no amendment to this. So at this point in time, there is no penalty that we're looking at doing, but there would be fine that on-site towing was in violation of the two codes. So at this point in time, I'll go ahead and call for a vote. So all in favor signify by saying aye.
Aye.
All right.
Those opposed, motion carries.
Thank you, Commissioners.
Thank you.
Thank you.
You bet. Appreciate it. Thanks for coming in. Let's move on to H3. Melendez, who's here? Mr. Sharp. Toribio Melendez, is that right?
Toribio.
Toribio.
Yes, sir.
We have before us Jason Danowski.
Danowski?
Danowski, I'm sorry. You've been before, and I think I butchered your name back then, too.
Well, I think this is
Okay.
the first time I filled out the paperwork properly.
Oh,
so-
okay, that's what it was. So, Mr. Sharp, proceed.
Good morning, Mr. Chairman, Commissioners. My name is Ken Sharp. I'm an enforcement prosecutor with the TDLR here. The respondent in this case is Toribio Servando Melendez. The department proposes the revocation of his registered air conditioning and refrigeration technician license and the denial of his application for an air conditioning and refrigeration contractor license. And I kind of stumble over that phrase from time to time. So with your permission, I'd like to shorten that just to ACR, the way we do up in enforcement.
Sounds good.
The department proposes this action based on two different things. First of all, the respondent's criminal history, and in second, the evidence that shows the respondent lacks the necessary honesty, trustworthiness, and integrity to hold a license. All right, this is the respondent's criminal history. In 1991, he was convicted of theft by check more than $20 and sentenced to 15 days in jail, although the court suspended that sentence. A few months later, in 1991, the respondent pled guilty to burglary of a habitation and was placed on community supervision on a deferred adjudication for 7 years. Now, the following year, however, the court revoked the community supervision, found him guilty, and sentenced him to 25 years in prison. Well, he was released on parole a short time later, but after his release in 2003, the respondent was convicted of theft, the value between $50 and $500, and sentenced to 30 days in jail. We also learned from the respondent that he was convicted of a theft from a Walmart in 2007. And then finally, in April 2016, the respondent was convicted of indecent exposure. The conviction records indicate the respondent had walked through his neighborhood completely nude on 3 different occasions over a 2-day period. Now, under the Commission's guidelines, crimes against property and crimes involving prohibited sexual conduct are directly related to the occupation of ACR technicians and contractors, and that authorizes the Commission to deny the contractor license application and to revoke the registered technician license.
Mr. Sharp, was the charge for Walmart submitting evidence
It was not. Well, only by his testimony.
by his testimony?
Yes, sir.
Okay, so it was in the evidentiary hearing.
Yes, sir.
Okay, so proceed.
The second basis for the Department's proposed action is the lack of honesty, trustworthiness, and integrity. First, the Department considered the burglary and theft offenses, of course, but more significantly, the respondent's more recent conduct makes this standard especially applicable. The respondent applied for the new contractor license in September of 2016, and he answered yes to the criminal history question on the application. And that question on that application, it appears on all our applications, and on the new applications, it asks if a person has ever been convicted of or placed on deferred adjudication for a criminal offense, a felony or a misdemeanor. Not minor traffic violations, but actual criminal offenses. And the application process requires the applicant to complete a criminal history questionnaire for each deferred adjudication or conviction. And on that questionnaire form, the applicant is directed to describe exactly what happened that constituted the crime that's being reported. The second part of the evidence showing a lack of honesty, trustworthiness, and integrity appears on his criminal history questionnaire, or CHQ, we call it. I like that too because I don't trip on that as much either. On his CHQ for the burglary, he wrote one thing, but at the hearing, under cross-examination, he gave a completely different account of that incident. And number 3, in the CHQ about his indecent exposure offense, again, he wrote one thing, but again, at the hearing, he testified and gave a completely different account, equally implausible. Number 4, at the hearing, the respondent presented letters of recommendations, recommendations from character witnesses, and in particular, he testified that, emphatically that 2 of these character witnesses knew all of his criminal history. However, those gentlemen also testified, and they said that no, the respondent had not told them all of his criminal history before he asked them to write those letters, or before they wrote those letters. He had told them that he was involved in a burglary when he was younger, but he was not. He did not tell them about some of the more recent offenses, and certainly not about the indecent exposure. So he had not been honest with them either. Number 5, the respondent filed his registered technician license renewal in February 2017. Now, that was only 10 months after his conviction for indecent exposure. But on that renewal application, the respondent answered no to the criminal history question. And on renewal applications, they ask, have you been convicted of a crime or placed on deferred adjudication since your last license was issued? So that would have been a year earlier. But this was 10 months after his conviction for indecent exposure and since his last license was issued. But he answered no to the criminal history question on that renewal application. At the hearing, he said it was just a mistake. He said he must have been filling out the application too quickly. But every other response on the application was accurate. So there were no other mistakes. Now, in spite of all of this, the administrative law judge concluded that the evidence demonstrated the respondent does have the honesty, integrity, trustworthiness, and fitness to hold a license, and recommended that you grant the contractor license and renew the registered technician license. Based on the evidence, the department asks that you reject the PFD as it's written, that you revise the PFD consistent with the department's exceptions, that you revoke the registered technician license and deny the contractor license application. He might be fit for a license in the future, but based on his recent conduct and his amply demonstrated mendacity, he currently does not have the requisite levels of fitness, honesty, trustworthiness, and integrity to hold a license. Thank you.
Any questions for Mr. Sharp? Mr. Danowski, I believe that you're here representing Mr. Melendez, if you don't mind, state your name for the record.
Jason Danowski of Foster Law, representing Toribio Melendez, the respondent.
Mr. Melendez, are you going to be speaking, or are we just going to wait and see how that plays out, Mr. Danowski?
He's filled out a form, so he can speak if you'll have questions for him.
Okay, sounds good. Proceed.
Certainly. I'd like to respond first to the issues related to integrity, and in particular the two CHQs, the one for the technician application and the ACR application. So I want to try to lay out the timeline of these applications and the criminal history. So in the early 90s and in 2003, Mr. Melendez had a number of theft-related convictions, as Mr. Sharp mentioned. Subsequent to those convictions, he applied for a technician license and he disclosed that criminal background. He then was he was convicted for indecent exposure. He then filled out an application for the ACR license and he disclosed the indecent exposure. Subsequent to that, he filled out a renewal application for the technician license and did not disclose it. So at the earliest opportunity for each of his convictions, he disclosed the crime. So his testimony at the hearing and his testimony today would be that his failure to disclose the indecent exposure on the subsequent technician application was a mistake. He has not withheld anything from the department. He did not put it on the right form, but he put it on the earliest form that he was required to do so on. With regards to the testimony,
So, quick question.
Certainly.
Did he not understand the question that was brought to him when he answered no?
would you like to, Mr. Melendez,
If you want to state your name for the record.
My name is Toribio Servando Melendez. Basically, it's just habit. I would get online, because y'all would send me a little card saying it's time to renew. And just out of habit, I get online, pay my $20 fee. I just did it too quick. I mean, it was a mere accident. It wasn't intentionally done. I wasn't trying to miss the conviction question.
My question is, did you understand the question that was asked you?
Yes, I do understand it,
And
yes.
you answered no.
Yes, sir, I did.
So you understood what the question was asking you?
Yes, sir, I did.
Yeah, I just want to point out that the issue with integrity is whether or not he has the honesty, trustworthiness, and fitness to hold the license. And regardless of the basis of the error, by not disclosing the information, it does not indicate that he is untrustworthy or dishonest. He has disclosed all information to the department. The department is not blindsided by any of these convictions. At the time that they received the renewal application, it had already been disclosed.
But by his own admission, he admitted that he knew exactly what the question was asking.
That's correct.
So how do you state that he was not trying to omit anything when there was an error, when he knew exactly what he was doing?
I'm not sure I entirely understand the question.
Mr. Chairman,
but-
Brian Francis. I was wondering if the two of you gentlemen could speak a little bit closer to the
I'm
mic so
sorry.
they could be caught on real audio.
Is that
That's
me
Thank
as
you.
well?
Yeah, I had to talk to my
I
boss. so it's
apologize.
Yeah,
awkward.
you got a soft voice.
Yeah.
Like I do. He admitted that he read the question exactly what it was asking and still answered no.
Yes,
And you're stating that there was an error
correct,
and that he was not trying to omit anything.
correct.
But he just got through saying that he read the question and knew what he was asking.
Certainly. And so he didn't put the information on the subsequent application, the technician renewal application. And the application says, I'm going to try to phrase the language by memory. Mr. Sharp may get it correct, certainly. But it says, since your most recent renewal application, have you been convicted of a crime, been placed on deferred adjudication, et cetera? And Mr. Melendez said here that he did understand that question. Based on the fact that he did not disclose that information, but he had previously disclosed it to the department, indicates that he did not want the department to not know. I might have tripped into a bad double negative there, I
You did
apologize.
fine, you did.
But he was not actively seeking to hide this information from the department. We would infer that from the fact that he disclosed that information to the department.
Yeah, proceed.
So I'd like to, I understand your point about, since the last application. My question goes more to the root of the crime, the indecent exposure. That's kind of troubling.
Yes.
The type of license that he would have would allow him to go into homes to deal with. Yes, please. There just hasn't been a whole lot of time since that offense. Could you tell me a little bit about why that happened to begin with? And did it happen on 3 different occasions? Was there some testimony to that, or was it just one time?
I'm not familiar
The
with it.
incident itself.
Certainly.
Do I need to state my name again?
No, no.
Okay. I mean, basically, it was a woman I've just been talking to for like 2, maybe 3 weeks. I can't remember the exact time. I'm a single man. I live at my house.
Before you proceed, this was all submitted into the hearing?
Yes, sir.
Okay, you
Yes,
talked
sir.
about this.
Yes, sir.
Okay, go right ahead.
Yes, sir. So, of course, we made plans to meet at my house, and basically, this wasn't something that I planned what happened as far as the indecent exposure goes. We were just talking, things led to one thing. I went to the restroom, come back, finished drinking what we were drinking, and I guess 20, 30 minutes later, this is when this happened. Of course, we were undressed in my living room, and I didn't know what I was doing. I ran outside, and that's how I got indecent exposure. So, of course, I got arrested, went to jail. They gave me a PI that time, so I came home. I was thirsty, drank water, took a shower, and eventually it reacted again. I don't know, but it happened again. And of course, I got arrested, and that's when I got the indecent exposure charge. I stayed in jail for, I think it was like 24 hours. Got out on a, I guess, pre-release type thing. Going back and forth every month to report until I had a hearing date. Went to a hearing date finally, I guess 6, 7 months later. I don't know the exact time. And got a $500 fine. That was my conviction, is a $500 fine. I am on parole. I did go to my parole officer about this because they knew about it, so I went to her and spoke to her because getting out of TDC, I had to go through SAFE and all that, program stuff. Asked her to.
Can I ask you a question?
Yes, sir.
Indecent exposure is a misdemeanor.
Yes, sir.
Why would you go to TDC for a misdemeanor?
No, I'm on parole. I have a parole officer, so I mean she knows about.
Prior to the indecent exposure, you had a parole officer?
Yeah, I'm on parole now. Yes.
For what offense?
For the burglary of habitation.
Okay.
Yes, sir.
I'm sorry. That's what I was trying to get at.
Yes.
Okay.
So
When is your
anyway,
parole- when does your parole end?
2020, 19, 2020, something like that. Yeah.
2020.
2020, I mean, I'm good on parole. I mean, I don't report, but every 3 months, I'm on quarterly reports now. But, I just went to my parole, spoke with her. Just as a precaution, I asked to go back to which is an aftercare with my counselor, just, to not let this incident happen again. I mean, I'm trying to do the right thing in life.
I appreciate that, Mr. Melendez. And it takes a lot for you to come up here and admit, all that you've done. I would just ask you, from our perspective,
Right.
you have burglary of a hab, you've been to the pen over it, indecent exposure.
Yes, sir.
The path that you're on is a very scary path.
Yes, sir.
And so our job is to, ensure the public safety as much as we can. And so, this is, you're pushing it.
Yes, sir.
The strings of credibility here, and asking us to allow you to go into homes, is a tough road to hoe for us, I
Right.
think.
And I understand, and I respect, what y'all are going through, and what y'all are doing for the state of Texas. But, I mean, like my recommendation of letters that I've got from people, customers that I've worked with, I mean, even on our website for the company that I work for, I mean, you feel free to look up our website, go through our reviews. I mean, you can see all the reviews I have on myself, which is Toby, that's what customers know me by. I mean, I'm trustworthy. I mean, I treat customers well. I don't mess them around like some people do. I'm honest. I mean, I relate with their kids. I mean, I'm interacting with people.
Would you
Yeah.
say that the crimes that you've been found guilty for are direct, there's a direct correlation to your license?
What do you mean, like?
So the license that you currently have, is there a direct correlation between the license that you have and the crime that you've been found guilty for? The burglary of a hab, indecent exposure, and because of the fact that you're exposed to
Right.
individuals in the public?
Well, I mean, I would think it affects it, yes. I don't understand the word correlation. I don't, like.
Does it relate to your license?
Oh, yes, yes. I mean, it does. But I mean,
Yet you're asking us to grant your license.
yes, sir. Yes, sir. I mean, I'm not that person. I mean, I've changed. I mean, I had a past. I've made mistakes. I made bad choices, you know, but I've done all that I can to classes, help, you know, to get me to where I'm at today. You know, I own my home. I have grandchildren. This is not just for me. It's for my family, you know. I'm embarrassed about what I've done. Ashamed.
And it takes a big man to admit that.
And that's why I appreciate you coming up here, Mr. Melendez. You know, it says a lot about you, and you know, but we can't forget everything that's happened.
Right, I
You live in this
understand.
tapestry of your life, and that's what we have to face. And so I appreciate you coming up and facing it and talking to us. It takes a lot to do that. I'm encouraged by that. Because you still have a lot of life left to live. And I think, you know, my prayer for you is that you go out and make you know, amends for all that you've done by the life that you live. You know, the proof is in the pudding, and I hope you go on and do that.
I will.
Because this is a great start, I think, to it.
And I would echo Commissioner Butler's sentiments right now. I think it's not easy to come before this commission and request that you be able to obtain your license based on your criminal past and your history. I know it's not easy. And I hope that, as you mentioned, you do appreciate the fact that it's difficult for us because of the fact that we know that you'll be out in the public. And there's nothing that prohibits you from going into houses where there are individuals, men, women, children, that are located in those houses based on the past that you have. So it becomes very difficult for us to be able to figure out a right path. As was mentioned earlier, you still have the opportunity to be able to apply later in the event that this commission chooses not to grant and revoke your license. I mean, if we choose to revoke your license, you know, I can tell you that in the past, we've done a little bit of everything. We revoked the license. We've granted a probationary status based on the fact that you follow the rules. So I'm not sure which direction that the commission is going to want to go, but I do want you to know, and I acknowledge the fact that you came before us, and I know that it's not easy, and that you have actually sat there and admitted in your crimes, and I think very eloquently stated that you're embarrassed by it, which is not easy to do. So for that, I do appreciate it.
And just one thing, I mean, whatever y'all decide on, I mean, stipulations, probationary, I mean, I'll follow whatever it takes to do this. I mean, this is my life, this is my future, you know, this is my career. And whatever it takes.
Any other questions for Mr. Donowski or Mr. Melendez? Thank you, appreciate it. Ms. Sharp, you good?
I could provide additional background if you wanted, if it's not consistent with what he just said.
What part be inconsistent?
Well, for one thing, when he first reported the indecent exposure to the department, he said he was simply urinating outside because the urge was too strong for him to go inside to make it to the restroom. Then when he testified, he said, now this is kind of consistent, he said that he had had a woman he knew for 2 or 3 weeks, but he couldn't remember her name. And they had an intimate relationship. They went to his house and were having this romantic, intimate involvement. He went to wash up, but when he came back, she must have poisoned or drugged his tea because he drank it, and then after a few minutes, 30 minutes or so, he had this strange sensation and irresistible urge to run outside nude, and did. And then, as he said, he got arrested. And then later on, he came back, he took a shower, got the urge again, and ran outside nude. And then there was a third time on Exhibit G, page 9 of Exhibit G. It tells the story that the officers who investigated the incident had and presented to the court, and that's what he was convicted of. But it was the inconsistent part is that he didn't know the woman's name, although he had this intimate relationship with her. He had this, what he described as a horrible condition that caused him to do things uncontrollably based on this woman who poisoned him, excuse me, or drugged him. Excuse me. He said he asked the police officers to take him to the hospital instead of taking him to jail, and they didn't. But when he was released, he didn't seek any medical attention at all on his own. Even after the third time this thing happened, he never sought any medical attention. He never went to authorities after he was released and after he was no longer under the influence of the substance that he said he was under the influence. He never went to the authorities to report the poisoning or the drugging that he said this woman had done to him. So that, and then coupled with the fact that instead of doing those things, he went and asked to go back into aftercare for this parole officer because, of course, as shown in the evidence, drug use is a violation of his parole. So he asked to do that, and they let him, and that's fine, that's good. I think it's less likely that some woman had drugged or poisoned him than it is that maybe he had become involved in something else on his own. But the inconsistencies in the story, the implausibility of the story, all of those things, just, the fact that they don't add up and that they're not consistent with reality and the other things that he said, all of those things, I think, again, support the department's position on this.
Any questions, Mr. Sharp? Mr. Danowski, last chance.
No, I mean, I did seek help. I mean, it's not, I'm not lying about anything.
All right, appreciate it. Thank you. Go ahead and close that. Commissioners, discussion or a motion to be in order?
I make a motion that we modify the PFD, and I'd like to address several of the finding of fact number 20 should be changed to say the respondent does pose a threat to commit similar offenses if licensed. There just hasn't been enough time. The seriousness of that. 2 indecent exposures. A third indecent exposure is a felony, which would require sex offender registration and a minimum prison sentence, unless they found you pled to a deferred or some kind. So you're very lucky you're not in TDC and having to register as a sex offender for the rest of your life. That's what a third indecent exposure gets you. You were convicted on 2, I guess? And so
Just one.
One? Okay. I'd like to also address conclusion of law number 12. It says you should be changed, and I'd recommend revocation, and conclusion of law 13 should be changed to deny licensure.
We have a motion on the floor.
Second.
A second.
Second.
Comment?
Yeah, responsibility of the citizens of the state of Texas is huge, right? That's our first and foremost. But the understanding that a man's vocation or a woman's vocation is important in order to them to be able to perpetuate a life. And it's been echoed many times, your ability to face forward the challenges that you've done and face them head on. It's embarrassing, but it's also a step in the right direction. I agree with Commissioner Butler that it's a recent enough that I've got the barrier for you to be able to enter a home or my family's home or anybody's family's home has got to be fairly high to ensure the state of Texas citizens that they're getting, an individual that they feel that they could trust, such as state. And I just don't see that time has lapsed enough. I say all that in the sense that I think it's pursued, or it would be wise for you to continue to pursue the career that you've done, because if it is accurate what you state that you are doing a great job, there's a great need in our state for good contractors as yourself. Give it some time. I think that's important. That would show consistency in my mind the next time you came up here, that in the length of space between this time and the next time that you apply.
We have a motion and a second. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Staff will get with you. This is not your only bite of the apple, as they say. You have some other opportunities. Also, just know that you will be able to apply for a license in the future. This doesn't prohibit you from not having a license. Okay? But staff will get with you and they'll talk to you about it. All right? Thank you. We appreciate you coming before us. Let's move on to Guillermo Willie Ruiz. Mr. Sharp?
Yes, sir.
I'm going to hand you something I've given to opposing counsel and general counsel.
Was this presented
Yes, sir.
at the hearing? Okay.
And it has some highlights.
Are there pictures?
Big, small letters.
Mr. Sharp, proceed.
Thank you, Mr. Chairman. Again, my name is Ken Sharp. I'm an enforcement prosecutor with the department here. The respondent in this next case is Dr. Guillermo Willie Ruiz. He applied to renew the audiologist license that was issued to him by the Department of State Health Services in 1988. The administrative law judge recommends that you deny that renewal application and revoke his license. In December of 2015, the respondent pled guilty to the felony charge of Medicaid fraud. He was placed on deferred adjudication and community supervision for a period of 5 years. Specifically, the respondent knowingly presented or directed his staff to present unauthorized claims for payment under the Medicaid program. And these claims were for audiologist or hearing aid fitter and dispenser services. The fraudulent activity extended over a period of more than 3 years, from February of 2008 to August of 2011. Dr. Ruiz pled guilty to knowingly violating the Medicaid fraud law. In fact, he signed a statement in court documents in which he unequivocally admitted he committed the crime. Now, the respondent made an initial restitution payment of $400,000, and the court ordered him to pay an additional restitution in the amount of almost $305,000, which means he's obtained almost $750,000 from the fraudulent activity. Understandably, the trial court ordered him to surrender his Medicaid provider authorization, which should preclude any further Medicaid fraud, but the court allowed him to continue practicing under the supervision of a licensed audiologist. So, the respondent could continue to bill insurance companies and self-paying parties, and that's a concern of the department because he would still have the opportunity to commit dishonest acts in his practice. At the hearing, the respondent presented the testimony of a number of character witnesses who assured the administrative law judge that they were confident the respondent would never again commit any crimes. However, many had known the respondent before and during the time he was committing Medicaid fraud, and they admitted they never would have suspected him of committing those crimes at that time either. In fact, that includes Mr. Dwayne Lowe, who's, I think, is Exhibit 2, or tab 2 on that exhibit that counsel just gave you. The respondent testified that his practice as an audiologist provided benefits to veterans and to needy people, to poor people who would not be able to obtain those kind of services if it were not for him. Ironically, however, the purpose of the Medicaid program is to help needy people. I mean, that's the very purpose of it. And that's the very program from which he had fraudulently obtained more than $700,000 over a period of 3 years. The ALJ noted the respondent's primary evidence of rehabilitation was the fact that he was paying monthly restitution, or was making his monthly restitution payments. But the ALJ also noted that he did not have a choice, that he has to do that. That restitution was court-ordered. The ALJ concluded that the circumstances of the deferred adjudication make him unfit for a license at this time. Now, finally, the ALJ pointed out that 6 years had passed since the apparent termination of his criminal activity, but the ALJ, who heard all the respondents' evidence in the testimony, all the evidence in the case, nevertheless concluded that at this time the respondent does not have the honesty, integrity, and trustworthiness necessary to hold the license. The ALJ recommended that you deny the renewal application and revoke the underlying license. The department asks that you adopt the PFD as written.
Any questions for Mr. Sharp? Okay, I've got Franklin Hopkins and James Hicks.
James Hicks.
James Hicks.
If you don't mind, I'll speak, and Franklin will speak, and Dr. Ruiz will be here for
Okay,
answer
I'm gonna
questions.
need one for each one of you.
Okay, yes, sir.
So, yeah, if you don't mind, just fill it out at the end. You're good right now, and just bring it to me. So, did you sign this, Mr. Hopkins?
Yes, I did. Mr.
Or-
Hopkins signed it, Mr. Hicks, I haven't
Oh,
signed
I'm
it.
sorry, you're Hicks, that's Hopkins. I'm getting confused here.
I'm sorry about that.
Okay, that's fine. So I'm gonna cross your name out, Mr. Hopkins, and put Hicks.
Okay.
Okay, wait a second. Again, who signed this?
I did, so he'll sign this one. I'll fill it out for me. So.
Who's on first?
Boy, I feel like that's what's going on here. Okay, so, I don't know who's gonna proceed.
I'll proceed first.
State your name for the record, please.
James Hicks, on behalf
Okay.
of,
Proceed.
on behalf of Respondent Guillermo Willie Ruiz. I call him Dr. Ruiz, just the way, he's a doctor of audiology, so the way one might refer to a PhD, but it's.
Go right ahead.
Either or is fine.
We know who we're talking about.
Yes, exactly. We don't have a ton of factual dispute, thankfully, in this case. I would just correct one thing Mr. Sharp said. There's no evidence in the record that he obtained $700,000 through Medicaid fraud. His community supervision for the felony offense of Medicaid fraud from $20,000 to $100,000. And I think what he's referring to is the amount of restitution that he's been asked to pay as part of his community supervision is not the same thing as him obtaining close to $1 million through Medicaid fraud. In any event, Mr. Ruiz, and Dr. Ruiz, as I'll refer to him, did plead guilty to Medicaid fraud in 2015. There's no dispute about it. He owns that. He'll be happy to answer questions about it. He essentially hired a hearing aid dispenser who was licensed audiologist in Mexico. He was not careful enough to make sure that dispenser had a valid Texas license.
I think we're starting to get into something now that wasn't presented.
I'll change the topic.
Yeah. Make sure that anything that you're stating has to do and was brought up before the hearing. Anything outside of that, as you see, they'll stop you and say that it wasn't.
Sure,
We can only consider those things that were presented at the hearing.
Sure, I believe the basis of the charge against him was discussed at the hearing, but I'll move on. Dr. Ruiz has paid over $500,000 in restitution, and today we're asking, as the administrative law judge said in her proposal for decision, that probated suspension is a possibility that the commission may wish to consider in this case, and we're asking you to consider it today because we believe Dr. Ruiz isn't a threat to commit dishonest conduct in the future. That's on page 11 of the proposal for decision. What you're faced with here is deciding whether or not Dr. Ruiz is fit to have an audiology license. By way of brief statutory background, there's Chapter 53 of the Occupations Code, which governs all licenses. There's Chapter 51, which governs the TDLR statute specifically. And what how the PFD reads is essentially there wouldn't be evidence under Chapter 53 that's on page 10 of the proposal for decision under Chapter 53 to support denial of his renewal application and revocation of his license. But, and I thought we'd won at that point. I kept reading, and the ALJ then holds that the question here, she says, is a broader question of fitness under Chapter 51. The TDLR has broad discretion to make a determination of fitness. Looking at the Chapter 53 factors. That confused me a little bit, but I would want to point out the Chapter 53 factors because I think that's the rest of that paragraph on page 11. She then goes into her explanation of why the factors cut in favor of denial and revocation, and I can explain why we differ in our conclusion. The factors under Section 53 talk about the extent and nature of a person's past criminal activity. This is the only crime in Dr. Ruiz's record. There's been 8 years have passed since the last criminal activity stopped in 2011. He was in his 40s then. He's 57 now.
Conviction was when?
The conviction was in 2015, December 2015. That's true.
So it's a recent conviction.
It is a recent conviction, 2015. He's under a community supervision that will expire in 2020. He's has made, as we've discussed, a good deal of restitution payments, and he's made them timely. He had a letter that we offered into evidence, and that's tab 5 in the folder we've given you, which is from his probation officer, wherein the probation officer concludes, and it's clearly in your jurisdiction to make these sorts of, but this is evidence, that he says it is of the opinion of this officer that the defendant does not have the propensity to reoffend, and that he be allowed to keep his professional audiology license. That's the same conclusion that the judge who entered his community supervision came to when he went at the end of the terms of his community supervision, writes specifically that he's allowed to keep his audiology license if he practices under the supervision of a licensed audiologist. So that is the purview of the commission, but those opinions are evidence. That one of the factors is the conduct and work activity of the person before and after the criminal activity. Dr. Ruiz has practiced audiology without complaint, without any board issues, since 1987. He is, by all accounts, an excellent audiologist, and he has never had any patient care issues. Those aren't what we're discussing today. Evidence of the person's rehabilitation and rehabilitative effort, and other evidence of fitness, including letters of recommendation. Those were provided extensively at the hearing. Dr. Ruiz had 8 character references appear. They talk about, we talked about his steady employment with the Hearwell, Texas group. He's no longer practicing as an audiologist during this time, obviously. But he is working as a business manager, making sure that the company does everything right. There is an MD who sees all the patients. There is a hearing aid fitter and dispenser who's in training, who's taking his test shortly to be licensed. We talked about his 3 now adult kids. The youngest, his daughter, is a freshman in college, and so he's supporting his dependents. Still are under the Chapter 53 factors, maintaining a record of good conduct. I mean, you just don't get any better in terms of good conduct here. He helps the poor, he helps the needy. We had witnesses talk about how he's given hearing aids to people in need. We talked about how he helps churches in need, not just in this country, but in Brazil, Turks and Caicos. He had one of his character references came from Turks and Caicos to testify at the hearing. We talked about how great a father he is. His entire family's in the church choir, and he's involved in ministry activities, including serving the poor. Basically, I think we've done everything that you could possibly do under Chapter 53, and I think what's being decided here, if I read between the lines on page 11, is essentially Medicaid fraud. Is it? I mean, if you got Medicaid fraud, based on the guidelines, I guess that the position is that it casts a doubt about integrity and honesty. But I don't read the guidelines as saying the bright line rule that Medicaid fraud and you can never make your way back with however many Chapter 53 factors. Instead, the Chapter 51 refers specifically.
Medicaid fraud committee? What was it?
3 years from 2008 to 2011, and I want to be careful because I believe Mr. Sharp believes we didn't discuss the basis of it, but it is in the PFD at page 5.
From 2008 to 2011.
Sorry, 2008 to 2011, and
Okay, that's fine.
yeah.
So now you're coming before us and saying that there is no question about integrity and trustworthy when this was committed over a 3-year time frame.
Well, we're not saying that there's nothing wrong with committing Medicaid fraud during a
There's nothing wrong with
3-year time.
committing Medicaid fraud?
No, we're not telling you that. I'm not telling you that it doesn't raise a question. The point is that when you look at all of the Chapter 53 factors, I think we've proved with mitigating factors that he is a person of integrity, that he has a reputation for trustworthiness, that he didn't go, it wasn't his intent to go out and scam people. That wasn't,
How was that not
that's
his
not the
intent?
way the PFD,
I don't
that's not
understand
the way
that.
the proposal for decision reads when it discusses.
Right, I understand,
when
but
it
I don't
uses
understand
Medicaid
how is that not his intent?
Well, as Mr. Sharp has said, I mean, we can't get around the
Yeah, but
the
your
knowledge
statement that you
element
made right
of the
now was that
of
this was
of
not his intent, and it was committed over a 3-year timeframe.
that's correct. It was
So there
recklessness and
was some
carelessness.
intent.
There was criminal recklessness with
no intent.
with respect to his employees that were under his supervision, and that's why we're here today. That's why he's paid so much in restitution. That's why he's been punished by the state, and that's why we're here today to discuss his license.
Okay, well, you just brought up another question when you said the employees under his care,
Supervision.
supervision. So it was the employees that did it?
The employees, the employee that was unlicensed.
Mr. Chairman, we didn't get into all that.
Okay.
On page 8 of the PFD, it says Mr. Ruiz testified that he pleaded guilty to Medicare fraud in December of 2015 and takes responsibility for his own actions. What are those actions?
Well,
What are his own actions? Obviously, that was addressed in the hearing because it's
Sure.
it's in the PFD.
it's billing Medicaid. It's billing under Medicaid, under the false under a false pretense, essentially. So that he's taking responsibility for those actions.
So
That's
he
what brings him
signed,
here
he
today.
signed it all, you know, when it was submitted to Medicaid. It was under his signature, you know. I've been in a profession for over 30 years that I know everybody knows has a major issue with Medicaid fraud within the orthodontic community. I'm just doing this from background, and I guess my question is on that Chapter 53 second part here that said, employment of a person in a licensed occupation would create a situation in which the person has an opportunity to repeat the prohibited conduct. Okay, and to me, if his signatures were on there and that's what was submitted for the fraud, this allows him to have that opportunity again. And I guess I have a slight issue with that.
Well, and the judge addressed this directly. He's not billing Medicaid anymore. If he had an audiology license, he wouldn't. He was as part of his crime and punishment under the terms of the community supervision. He had to surrender his Medicaid card, and he has no intent of doing that. Now, the judge also makes the point that's being made is that there's opportunity for dishonest conduct generally in terms of billing, but on the direct point about Medicaid fraud, it's just not going to happen again because he doesn't bill Medicaid.
But there's insurance billing, and then there's private pay customers as well. I mean, so if the only evidence that we have of his rehabilitation is his restitution, that just tells us that he just got caught.
Well, I wouldn't I wouldn't agree that that's the only evidence that we've presented of rehabilitation when he has
Sure.
eight character references.
Yeah,
talking about
but was he doing was he giving out free hearing aids and doing the Turk and Caicos trips before he got caught and during the time that he was?
There's no dispute, and
Right. So all of this was the good works were taking place before, during, and after the theft. The only rehabilitation is the evidence is the restitution, admitting something was stolen that wasn't justified.
I think that there's no dispute. I think what's being asked is that we present character references
Sure.
that would
I
say that
understand.
he was a filthy liar before his crime, and it just wasn't true. I mean,
But the character references that you submitted, I believe it was stated that even they were surprised that he did this.
And you've got a tough road to
That's
hoe.
true.
I mean,
Absolutely.
yeah,
That's true.
It's
They
admirable
were
that y'all come up
surprised
and you put lipstick on a your case.
So you're asking us, okay, let me backtrack. So you have 8 character references for the respondent that also stated that they were surprised at what happened.
I don't know that all stated that
Well, okay,
that
there was-
specifically.
Okay, there were a few, I'll put a few, that were surprised at what happened, who knew him. And now you come before the commission, who we first time we've seen him, met him, all the information is on paper, and you're asking us to believe him when the people that are his character references found it difficult to even believe that he, imagine that he did this to begin with. Is that what you're asking us?
Medicaid fraud is a serious offense, and for somebody of such integrity to be charged and plead guilty to it is surprising, and was surprising to the character references we talked to. Absolutely.
Okay, well, and we can go into a whole discussion about the integrity aspect, because I think that's where we're at here. I'll just leave it at that.
You're the civil administrative?
We're the administrative law
And
counsel.
you're the criminal administrative lawyer?
No, sir.
You don't mind state your name for the record?
Franklin Hopkins. I did the hearing with Mr. Hicks. We represented Dr. Ruiz. And it is a tough road to hoe. We're not getting up here and saying it's not. We're actually trying to paint a full picture of him, because obviously all we have is, y'all need to lay eyes on him. This program got transferred from DSHS, Department of State Health Services, where he had an admirable career, except towards the end, he has this conviction that's absolute. And to go back to something you said earlier, and we won't get in the weeds too much, but, as Dr. Wesson pointed out, if you sign something for Medicaid, even if your employees are doing the underlying work, it's your signature, you're responsible. And he's responsible for himself, his actions, and what his employees do. And if his employees are doing bad stuff, then that's on him for being a negligent hire, for being a bad supervisor. And he's taking that forward as a lesson learned. The thing that's admirable about Dr. Ruiz is that he still obtained and was able to find employment despite all this. And his employer knows about this, and he's still here. So, we do have 7 years almost, I guess, since the last criminal incident, but yes, it is a recent conviction. So what do? It is a tough position. I think there are a lot of options. One thing is, he's not, I think the issue is addressed, he can't do Medicaid, Medicare, because he's not allowed to. The judge won't let him. He goes to prison or jail if he does that. It's up to you. If you're worried about insurance, to show some kind of more rehabilitation potential, you can make, restrict him just to private payment. I mean, that's doable for like 5 years if you wanted to. I mean, if you want to make him, we could submit charts if you wanted to of his billing to see if he's improving. As far as rehabilitation potential, I will say that there is the restitution payment. Mr. Hicks hit on it. I believe it was in the PFD about a conviction for $20,000 to $100,000. Obviously, Dr. Ruiz has to pay a lot more than that. That's part of the system. He understands it. He needs employment, and obviously his license to keep paying this hefty payment. He's still paying that payment to the government, and he knows that. He signed up for that. But I will say in terms of rehab, the steady employment counts before and afterwards. He could have given up. He obviously didn't. This is a lot of stress on him, but obviously he committed a crime, so he has to keep going with that. But you've seen the letter from the probation officer. Mr. Hicks and I reach out to a lot of probation officers, and sometimes it's not the most kind response when we call them. And this person was willing to write a letter, and I was surprised. And they said, he has no propensity for offense. So that's something to see right there. I think that's a lot of weight. That might be the most weight of any of the witnesses, because obviously other people were characters, but they knew him. But you see that this is his only crime. I know it's a big one in his whole entire career since 1988. So I think that's something that factors in. You take the whole body of evidence of what he's done. But I understand, that you can't not do anything. But what we're asking is, I don't know if it can be a 5-year revocation, maybe probated, and then, he's basically under probation for 5 years like he is now. He's under probation for a year or two more, or how long? 2 more years. And so I think you should consider all that. And Dr. Ruiz is willing to answer any questions, that y'all might have, or we'll answer any more questions y'all have from, what we've presented. But again, I would ask y'all to look at the Chapter 53 factors, because there is a lot there.
Well, I tell you with all due respect, the parole officer may have stated that there is no propensity for future, but I think if prior to the knowledge of the other 7, they probably would have said the same thing. They don't see how there's a propensity for theft out of Dr. Ruiz.
Correct.
I have a couple questions. How much more restitution is yet to be made?
State
Dr.
your
Guillermo
name for the
Willie,
record, please.
Guillermo Willie Ruiz.
Make sure he signs one of these also.
Say, repeat the question, sir.
How much more restitution?
Approximately less than 200,000, I believe, or close to it.
So, Dr. Ruiz, your attorneys have done a great job for you. Splendid job. We see a lot of them, and they're some of the best. But everybody's mentioned how at worst you're a bad manager. What did you do? What did you do to bring us here today?
Well, like it's been stated, as very well said by the dentist here, Representative Mr. Wesson, we're responsible for the supervision, and we ultimately are the ones that sign the claims, and basically I did not do a good job of proper supervision, and these claims were submitted, and they should not have been submitted.
So your underlings did something wrong. You did nothing wrong other than.
No, sir. I'm responsible
I'm not hearing
ultimately.
that.
No, sir. I am I'm responsible for everything that happened, no matter who or what. I am responsible, sir.
So you're kind of the victim in all of this.
No, sir. No, I'm not the victim. I am the one that the buck stops with, and I'm responsible for what happened, no matter who or what or when. Yes, sir. Sir, may I add something? I don't do any billing at all now. I don't bill private. I don't bill insurance. I'm not doing anything. I have not done, because I've been very unsure as to what my status as far as licensing, and even though I was told that during this period, because we haven't been renewed, so I've been very careful not even to do too much other than basically work in the office and just do marketing and phone calls and stuff like that. I'm not billing, and I'm willing to, I could work for someone under their supervision and just do basic, audiology for them as well, and not be even doing any kind of billing whatsoever, whether it's private pay or anything. I could actually work for someone, and that's it. Do rehabilitative audiology or just the basic hearing, what we're trained to do, and not be responsible for any billing. There are state agencies, there are nonprofit organizations, hospitals, where we just see the patients, and I can work for an ENT or work for another audiologist, and not be involved in any billing whatsoever. Just work for somebody and not be involved at all in any kind of billing or money.
And that is an option, commissioners, is that, he can have the license, but then obviously that's the threats or the issue of billing is obviously addressed because he can't do any billing. You can give him a license, say he can't bill anybody. There's nothing stopping him from having that restriction.
How is that monitored, I guess is my question. If you go to work for somebody and they sit there and say, well, hey, you're doing this and we're going to move you over to here, and then you get back into that, how do we know? Or how is that monitored?
One way, sir, could be that he, provides his supervisor that he has an MD now, but he could provide his supervisor's name, and that they could send in a monthly attestation letter that he's not billing. We could submit charts to the department to show he's not billing. I think obviously in the ALJ addressed that. The issue with him is he's not a threat to the public. Like, there wasn't an issue with harm. Like, he's fine with patients. He's good at his job. The issue obviously was fraudulent, relating to billing, relating to money. So if we take that address that concern there, then we have somebody treating people, he knows how to treat them, but he's not billing. But that would be one option, is his physician or his supervisor. He would have to provide the name to y'all within so many days of today. He have to submit charge. That person could submit a letter, obviously, that he's not billing. We're obviously very flexible with that.
But the license itself gives him that opportunity, right?
Yes, sir, unless there's a restriction in it, put in by the commission today.
But from a staff standpoint, that's a hard thing to monitor, right?
Very difficult.
Yeah, we're not equipped to be able to handle charts coming in, letters, stuff like that. Really, the only restriction that we could put would be, if he's got a suspended license probated, that's about the extent of what we can do. It's just difficult for us to have somebody that would monitor his daily activity.
No, sir,
There's no structure for that.
Mr. Chairman, I understand that, and so I guess one way, maybe the easiest way would be that letter from a supervisor every month, not charged, but that he's not billing. And then if obviously that doesn't come in, then y'all could revoke his license if that doesn't come in right away. Or every 6 weeks, however y'all want to do a letter from the supervisor. And that would be on him to obviously find a supervisor and obviously to submit that letter, and if not, then he could get, automatic revocation. A lot of healthcare agencies do that. I know kind of TDLR is becoming a healthcare agency, so to speak. So,
Well, I think, I appreciate those recommendations. The issue that I have is that we are now tying another individual to this PFD that we would be subject, that we subject you to.
Yes, sir.
Not knowing who that is, we're now tying somebody else into it, and I can tell you that I oppose that. I don't
Okay.
think we should not tie somebody else down for his mistake.
I'm gonna come at it a little different. I agree. But the contingent is that, you know, when you take a man's vocation away, it's a big deal in any capacity, and nobody wants to do that because it helps, I mean, in my mind, be able to do it under the contingent that they're not a threat, right? And I understand it. Ms. Sharp, I guess my idea is what more, as an enforcer, do you want him to produce to be able to, what would that be, in order to produce, to affirm that feeling? Because there's got to be there's got to be a light at the end of the tunnel somewhere. What else do you need to see that I'm maybe not aware of?
Well, I think there is. There's always light at the end of the tunnel. But I think it takes a complete reversal and not just a partial reversal and a kind of attempts to kind of skirt responsibility. And I know Dr. Ruiz says, well, I'm responsible because of my position, I'm responsible. But he didn't plead to careless or recklessly defrauding the Medicaid system. He pleaded to knowingly defrauding the Medicaid system, and that's what the element is. And they never would have brought that charge if they didn't have it. Now, granted, it appears that it was a plea agreement, so it went down to the $102,000 level. But restitution, as I think as Commissioner Butler was talking about, that's payback. That's make me whole again, restitution. Give us back what you took from us.
Which he's doing.
Which he's doing, and that's good. The other thing is that when he testified that he's not doing anything right now, he's not, but at the hearing he testified, yes, he is doing some testing, and it's on the ALJ's response letter to the exceptions to the hearing. I think it takes a complete turnaround. I think if he's going to be honest, he needs to be completely honest, and I think he needs to be to show that he has complete integrity and not just, well, it was somebody else's fault, but I'm going to take responsibility for it, and I'm not doing anything now that I shouldn't be doing, although I'm doing the testing and so forth, which he can under the trial court's order, or the criminal trial court's order. But from an enforcer's standpoint, I would like to see that complete turnaround. I would like to see the honesty, integrity, and trustworthiness that we can depend on rather than kind of the dodging the bullets as they come toward him.
So these are my fear is that these are going to be the kind of cases, as you alluded to, now that we're monitoring the healthcare licenses. And so going forward, is there an audiologist that's listening today saying, well, if I pay back the $1 million, I get to keep my license? Is it worth it? You know, maybe if I take 1.2 million, they won't catch that 0.2 million, but I get to keep my license. I'll pay back $1 million. Those are my fears. So if you were, an electrician and you were stealing from your clients, stealing from the taxpayers, would we trust you to continue in that profession? This is a guideline crime for audiologists. This is one of the big ones for us. Fraud and deceptive trade practices. Those, you kind of covered both in one fell swoop. So there's more here than just, this particular case.
One thing I may add is, and we're aware of no active investigations or complaints against him at this time. The crimes were in 11, and the conviction was in December of 15. But, some evidence you have that he's not going to reoffend is, he's kind of restricted himself personally in what he's going to do, but he still has this active license, and he's been performing in terms of, either restricting himself, but saying there's no cases we're aware of against him. So I think that's some evidence that he's on the road to rehabilitation, but that, there wasn't a temporary suspension or automatic suspension here. He's been practicing for years without that, with no incident is what I'm trying to say. So I think that's something to maybe consider. Another thing I'd like to throw out there is I understand, Mr. Chairman, about the resources, and I respect that. One thing, too, is, I don't know if it's possible if he can get, I know they sometimes have to reapply, which can be a long process through SOA. If he's maybe suspended, 9 months or a year, at the end of that suspension, his license is automatically reinstated. I think that could be a possibility as well if to show some kind of punishment there, if the commission so chooses.
Any other questions for Mr. Hopkins, Mr. Hicks, or Dr. Reese?
Did a great job, gentlemen. Thank you.
Anything else for
I just follow up on one thing that Mr. Hicks said, and he talked about and then Mr. Hopkins also talked about the ALJ mentioning the possibility of a probated suspension. But right after that, the ALJ said unequivocally, however, given these considerations, I recommend that you revoke the license and deny the renewal. So that's what the department recommends as well.
Thank you. All right, make sure we get those forms
Yes, sir.
out and brought to them. Do you need your binders back?
Those are for y'all, sir. Or do
They're
you want?
just gonna, they'll probably be trash. So if
Okay,
you
yes,
want
sir.
it-
Could have pictures.
And this is Brad Bowman, General Counsel. We'll hang on to one of them for the record in the case.
Yeah.
Yeah, I think,
I've got
well,
it.
you got one? They both have one? Okay, so you got one, perfect. All right, thank you, we appreciate your time. Commissioners, discussion or a motion will be in order at this time?
Make a motion that we recommend the PFD as recommended.
Adopt PFD.
I'm sorry.
We have motion and
I'll
second
second.
to adopt the PFD as presented. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed?
Nay.
We have 3-1 to adopt the PFD. So I'm sure you're aware you have the ability to have some other bites of the apple. So,
Been a year, I believe.
I'm sorry, yeah. So, but you can get with staff and they'll kind of let you know what your next steps are.
Thank you,
So,
sir.
we appreciate you coming in. Thank you. Let's move on to item number 5, Irvin Wilburn. Make sure I grab your forms before you leave, gentlemen. Oh, Dr. Reed, if you don't mind filling one out, please. Just bring it to me, it's fine. Go ahead, Mr. Thielen.
Good morning, Commissioners. My name is Trevor Thielen, a prosecutor with the Enforcement Division. We recommend that you accept the Administrative Law Judge's PFD, deny Irving Wilburn's Class A barber renewal application, and revoke that license based upon the danger indicated by his criminal history and because he lacks the required honesty, integrity, and trustworthiness to hold his license. In December 2015, at age 30, Mr. Wilburn was working at a barber shop while another man and that man's 13-year-old daughter were present. When the girl opened the door to exit the women's bathroom, she found Mr. Wilburn standing in the doorway with his pants and his boxers down around his ankles. Mr. Wilburn said, "Come on, let's do it," to the girl, who became scared, started to cry, and ran from the scene. Mr. Wilburn pled guilty to indecent exposure, and the court placed him on deferred adjudication for 1 year, starting in October 2016. Mr. Wilburn successfully completed the probation. The department discovered the indecent exposure after Mr. Wilburn applied to renew his barber license in May 2017. We sought to deny the renewal and revoke the license based on the offense and because Mr. Wilburn falsely stated on his application that he had not been placed on deferred adjudication for any new offenses since the last renewal. The ALJ recommended denying the renewal and revoking the license, but only based on the criminal history and not on the false statement. The ALJ found that the offense could be treated as a conviction because of the recency of the offense and because it was serious. Sexual offenses and crimes against children are guideline crimes that are closely related to the purpose for acquiring a license. Importantly, this offense took place inside a barber shop he was working in at the time. A barber license could afford Mr. Wilburn more opportunities to commit similar offenses. Mr. Wilburn submitted 4 letters of recommendation, but the ALJ noted that none of the letters indicated their authors were aware of all the details of this offense. Mr. Wilburn did not present any evidence of rehabilitation. We recommend that the Commission accept the ALJ's PFD and deny the license application and revoke the license.
Any questions, Mr. Thielen? Is there anyone here representing Mr. Wilburn? Commissioners, a motion to be in order?
So moved.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 6, Mr. Henry.
My name is Trevor Thielen. We recommend that you accept the Administrative Law Judge's PFD and deny Edward Henry's Class A barber license application as well. Mr. Henry's criminal offenses began in 1994 when he was 17. Between 94 and 2001, he was convicted of 3 charges of possession of marijuana, 1 charge of possession of cocaine, and 2 charges of possession of cocaine with intent to deliver. The last 2 offenses resulted in a 5-year prison sentence starting in 2001. During this earlier period, Mr. Henry was also convicted of an assault and a failure to identify. After Mr. Henry was released from prison in 2003, the department took a chance on him and issued him a barber license. However, this license was revoked by operation of law in 2012 when Mr. Henry went back to prison again. Went back to prison again after another conviction for possession of cocaine with intent to deliver. The cocaine was found in Mr. Henry's barber shop in 2011 when he was 35 years old. While he contends that the drugs were not his and he weren't aware they were there, a jury convicted him of possession with intent to deliver, and Mr. Henry admitted that no one else related to the barber shop was prosecuted for a drug crime. Mr. Henry was released from prison in late April 2017 and applied for a new barber license just 11 days after his release. The drug delivery convictions and the assault conviction were all guideline crimes that directly relate to the barber occupation. The fact that the last drug crime occurred in his barber shop shows that another license would give him similar criminal opportunities in the future. The crimes were serious, committed during his adult years. Mr. Henry, as an applicant, held the burden of proving his fitness for the license, but he did not provide letters of recommendation or more evidence of his rehabilitation efforts beyond his testimony that he took a few classes while he was in prison. Noting that hardly any time had passed since his release from prison to determine his fitness, the ALJ found that Mr. Henry did not prove that he has the honesty, integrity, and trustworthiness necessary to be licensed as a barber. We recommend the Commission accept the ALJ's PFD and deny the license application.
Is there anyone here representing Mr. Henry? Commissioners, a motion to be in order?
Can I ask a question? How old is Mr. Henry?
He was 35 when the most recent offense occurred, so...
That was in 2012?
2011. He was incarcerated in 2012.
His birth date was in 1976, so that would make him 42. 42.
Going on 42.
Just earlier this week he had a birthday.
Commissioners, discussion or a motion to be in order?
Move to accept.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 7, Johnny Spinelli. Commissioners, we have a letter. Actually, it's a note from a physician on behalf of Mr. Spinelli. He's had a medical issue. He's requesting a continuance from this commission to the next meeting. I believe Mr. Thielen, prosecution or the enforcement division, is opposed to this. Is that correct?
We are, for 4 reasons. This case was originally set on the previous commission meeting date on February 20th, and he indicated shortly before that he was scheduled for knee replacement surgery the day before that on the 19th and couldn't come to SOA because he'd still be recovering from his surgery. We didn't oppose that continuance, but he's already gotten one. The same day as the commission met on February 20th, General Counsel informed Mr. Spinelli that March 27th is the next commission date. That's when your case is going to be heard. He did not indicate at that time that that date was going to cause him any potential problems. His first request for this second continuance came a little less than a week ago, and it's the first that we're hearing about his continuing medical issues. In fact, the doctor's note showed up today. It appears it was mailed on Friday. We believe he had plenty of time to make arrangements for someone to represent him. He appeared at the hearing, the SOA hearing, with an attorney. That attorney doesn't represent him at this time, but he had plenty of notice of when the date was going to be to potentially hire somebody to represent him here today. Furthermore, there's no requirement that he be here for the case to be heard. The commission has gone against the department on other cases where no one has appeared to contest on their own behalf. And finally, I want to just note that because of the timing of his renewal application, before his most recent license expired, every time, the entire time that this case has been pending, and every time that we move it back from being considered in front of the commission, his license remains active. He remains a master electrician and able to exercise all the powers that come with that. We're seeking to revoke that license because we believe that he is a danger to the public. And if the commission issues a second continuance in this case, that will be 3 extra months that he has had that license from when the case was originally going to be considered. So we're opposing his motion for a continuance.
Commissioners?
Do you know if he's actively working as an
I-
electrician, especially with his medical condition?
I do not know, other than his doctor's note says unable to work. It doesn't list a date when he would go back to work. And it was dated
And
March 21st.
Mr. Chairman,
which was
Trevor, if we could kind of be careful about any details of the doctor's note or that sort of thing in the record. I think everybody has it, and because of that information, we want to keep that.
Commissioners, what is your
confidential.
preference on this particular case?
How many times do you get it moved? Or is there with no representation, you could have somebody here to represent him, I guess, right?
Good. I would tell you that, based on the question that you just asked, that if he no longer has a representation that he had at the SOA hearing, it would be difficult for a new attorney to come in and plead on his behalf because he did not attend the SOA hearing.
Okay.
It'd just be simply based on what's in the record.
Okay.
So what is your preference? Do you want to proceed on, march forward? Would you choose to grant another continuance? Commissioners?
I hate to go against a medical doctor's note, and I realize that the length and the delays and the frustration that's involved in it. But be that as it may, I'm still in the camp that a licensed medical doctor has noted his condition and validated it. So that weighs heavy with me.
In this particular case, I kind of concur with Commissioner Figueroa, as odd as it might seem.
Rare.
But I can tell you this, is that we will hear it in our May meeting as far as I'm concerned. I think that at that point in time, I'm not inclined to grant another continuance again.
I was going to say a decision will be made in May.
So I think we'll go ahead and grant his continuance. But whenever you visit with him, make him aware that this will be heard in our next meeting.
Do we need a motion?
I think we simply have to, you want a motion?
You may, this is Brad Bowman, you may want to
Okay.
take a vote. It sounds like there's
State that.
consensus,
I
but
move to give continuance, but to make sure it's communicated very authoritatively that May will be his last continuance. I mean, this is his last continuance.
I'll pass that on to general counsel, but
yeah,
I
this is
don't
Brad Bowman.
communicate
We'll
with him.
communicate that to Mr.
I'm
Spinelli.
sorry, I didn't mean to look at you. I meant to look.
We have a motion.
A second.
And a second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 8, Caleb Kidd.
My name is Trevor Thielen. We recommend that you accept the administrative law judge's PFD and revoke Caleb J. Kidd's electrical apprentice license. In 2007, at age 21, Mr. Kidd committed insurance fraud and was placed under deferred adjudication for 2 years. In 2015, he applied for an electrical license, and the department granted that license. Soon after that, in January 2016, Mr. Kidd committed 2 Class A misdemeanor thefts and was sentenced to jail time. Y'all can
Probably
still
wanna
hear
speak a
me?
little
Yeah,
closer.
speak up a little. Huh?
Yes.
In January 2016, Mr. Kidd committed 2 Class A misdemeanor thefts and was convicted and was sentenced to jail time. 16 days after being convicted of the thefts, Mr. Kidd applied to renew the license, and he answered no to the criminal history question. Because of the no answer, the license was automatically renewed, and the department didn't discover the theft convictions until he again renewed in 2017. When we discovered the 2016 convictions, we sought to revoke the license based on the criminal history and the false statement on the 2016 application. While the ALJ found that we did not prove the false statement portion, she did find that the license should be revoked based on Mr. Kidd's criminal history. The court found that the theft offenses directly related to the electrician occupation, that Mr. Kidd was 29 and an adult when he committed them, that he did not present any work history, rehabilitation evidence, or letters of recommendation. At SOA, Mr. Kidd denied that he committed the thefts, but the ALJ concluded that it must accept his guilty pleas and the convictions as true. We recommend the Commission accept the ALJ's PFD and revoke the license.
Anyone here representing Mr. Kidd? Commissioners, the motion be in order?
Motion.
Second.
We have a motion and a second. All in favor, signify by saying aye.
Aye.
Those opposed, motion carries. The motion was to accept the PFD.
Mr. Chairman, who made the motions?
I'm sorry, it was Commissioner Dr. Wesson.
Dr. Wesson? Okay. And then seconded?
Commissioner Figueroa.
Thank you so much. We just did not hear.
Couldn't hear past the lawnmower? Is that what the problem was?
That's Mr. Kidd's lawnmower service outside.
Okay, appreciate it. Thank you, Trevor. All right, let's go on to the motions for rehearing, and just so everyone knows, after the motion for rehearing, we'll take a short break. So we're all relying on a quick introduction for our motion for rehearing so that we can take a break.
No pressure. Good morning, Chairman, Commissioners. Dr. Wesson, welcome. My name is Doug Jennings. I'm Assistant General Counsel for the Department. We have one item on the motions for rehearing this morning, and that is John McGinn, TDLR versus John McGinn, DBA McGinn Electricity or Electric. This matter resulted from a default order in which the Department assessed administrative penalties against the respondent totaling $3,000 based on his alleged offer to perform non-exempt electrical work without the required license. In his motion for rehearing, the respondent alleged that he requested a hearing in writing via email correspondence with the Department, but no hearing was granted. We have reviewed the record and found that to be true. Consulting with the Enforcement Division, they agree that a hearing should have been granted in this case. Have actually taken steps to schedule a hearing with Mr. McGinn. I know Prosecutor John Medlock has been in touch with the respondent. And so we believe we have the concurrence of the Enforcement Division on this one, and we recommend granting the motion for rehearing in this case.
Commissioners, we have a recommendation to grant the motion for rehearing. Motion be in order.
So moved.
Second.
A motion is second. All in favor, signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Thanks, appreciate it. That concludes our cases and motions for rehearing. Let's take about a 10-minute break. When we come back, we'll kind of whiz through quickly the rules. So let's take a break. Hope they got the hand on that one. welcome back to our meeting. I do want to recognize a member of our Midwives Board is present before us today, so here to answer any questions. So Lori, appreciate you being here. So I did want to recognize you. And we had a gentleman from our ACR, but I believe he left. What was his name? I'm sorry.
Mr.
Cambion.
Yep, Cambion. He was here, but he said he had to be back in San Antonio, so he excused himself. So we are having members of our advisory board showing up, which I think is great. So, you can.
I just wanted to chat about Ms. Fringen for a second. We had a meeting a couple of weeks ago, and it was a pleasure talking to you and the other members of your board. You're so thoughtful, and
Mr. Chairman, and I just want to interrupt just briefly. We were actually on agenda item W1 that has the work group for the midwives, so just wanted to make sure that everyone knew we were on the agenda.
okay, great, thank you.
Yes, sir.
And I just wanted to say thank you for the attention that y'all take in your roles there, and it was very obvious in the discussion of the form that we were discussing and all the ancillary issues that surround it. And I just wanted to say thank you, and please pass that along to them, how much we appreciate the thoughtfulness and where y'all are going. Thank you, Brian.
Yes, sir.
Hang on. All right. Okay, let's move on. We are now on item J, discussion and possible action on the amendments to existing rules of the electricians program. Commissioners, what we're going to be having here are a lot of cleanup language, repealing of rules, of programs that are brought over to us from the Department of State Health Services. I won't call them dishes, but Department of State Health Services. So they're going to probably run through them pretty quick, but a lot of them have to do with just simply cleanup language. We do have some rules that we need to address, but a lot of it that you'll have before will be cleanup language. So just kind of so you're prepared what we'll be doing after this. Go right ahead.
Yes, thank you, Chairman. Commissioners, again, Doug Jennings, Assistant General Counsel for the Department. On Agenda Item J, we have proposed amendments to the electrical rules, which would implement House Bill 1698, which created the Journeyman Industrial Electrician Program. The proposed rules were published in the Texas Register on February 2nd of this year, and the public comment period closed on March 5th. We received a large number of comments on these rules. 21 interested parties submitted rules. However, most of the rules indicated some confusion on behalf of the public about the applicability of this license, since some work at industrial locations is exempt from the electrical licensing laws. And so we have already spoken with the electrical compliance, RPM team. They're putting together a frequently asked questions document that should really address most of the questions raised in the comments. And so as a result, I forgot to mention the advisory board did approve these rules last week at their meeting. We're asking for your adoption of these rules with one minor change to fix a typographical error in Section 7310 with an effective date anticipated of May 1st. Happy to answer any questions.
Any questions for Doug? A motion to be in order?
Second.
Moving second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item K, discussion possible action on proposed amendments to the air conditioning refrigeration program.
Thank you, Chairman, Commissioners. These proposed rules would implement House Bill 3029, which creates the new type of certified technician within the air conditioning and refrigeration program. The proposed rules were published in the Register on January 12th. The public comment period closed on February 26th. We received 3 comments during the 30-day comment period, in addition to an extra comment that we accepted after the deadline. A couple of the comments weren't really within the scope of the rules. One comment noted some errors in the first section of the rules, and I'll address those in a moment. And the last comment suggested that we implement continuing education for this license type. That's an issue that the ACR board is going to continue to look at, but we don't have any changes regarding continuing education. Right now we're asking, we also forgot to mention that the ACR board did approve these rules. We're asking you to adopt the rule proposal with some changes, and a couple of changes are needed to Section 7510 to correct some bad cross-references, and there are minor editorial and typographical changes that need to be made throughout the rules, which you will see in the rules before you.
Yeah, they note that changes were submitted to us, so we have that.
Yes.
So, Commissioners, any questions for Doug, or a motion be in order?
Motion.
We have a motion, and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number, item L, discussion possible action for proposed amendments to the speech language pathologist and audiologist program. Oh, that's a quick, put my head down and switch.
Hello, Wendy Pello, Assistant General Counsel. This is, I'm going to have agenda items L, M, and N. Just take them one at a time. Agenda item L is the first rule proposal relating to the speech language pathology and audiology program under Chapter 16 Texas Administrative Code, Chapter 111. And this rule proposal is specifically about Rule 111.212, which is the use of telehealth by speech language pathologists and the in-person initial contact requirement. The proposed rule is eliminating that requirement that the initial contact with the client must be at the same physical location to determine the client's candidacy for telehealth before any services can be provided by telehealth. And the proposed rule allows the speech language pathologist initial contact with the client to be either at the same physical location or through telehealth as determined appropriate by the licensed speech language pathologist. This issue has been discussed over the course of several meetings with the advisory board. In fact, we had a initial kind of kickoff in June 30th, 2017, just talking about the trends in regulation, what we were seeing with telehealth and in-person, specifically in-person initial contact. We drafted options for the proposed rules and presented those and discussed those with the advisory board at its meetings on November 15th, 2017 and January 4th, 2018. And then at its meeting on January 4th, 2018, the advisory board voted and recommended that the proposed rules be published in the Texas Register for comment. They were published on January 26, 2018, and the 30-day public comment period closed on February 26, 2018. The department received comments from 7 interested parties, 6 individuals, and the Texas Speech Language Hearing Association. You have those comments in your materials along with the department's responses to those comments. Based on the public comments received, the department was not proposing any changes to the proposed rules. The advisory board came back and met again on March 6th to review the comments and have a discussion, and the commission, and the advisory board recommended that the commission adopt the proposed rules as published. And the department is making that same recommendation with an effective date of May 1st, 2018.
Any questions for Wendy? A motion be in order?
Second.
So we have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item M, discussion possible action of proposed amendments to the speech, well, I guess speech language pathologist audiologist. This is basically the cleanup language, isn't it?
This is several things. Again, Wendy Pello, Assistant General Counsel. This is our this is, again, is the speech language pathology and audiology program. This is our large rule package. As you can see in our agenda, we've amended existing rules, added new rules, repealed some existing rules. There are 3 big categories of the changes we made. We made changes to implement House Bill 4007, which was passed this past legislative session. That was a lot of cleanup. We also have made other licensing and other cleanup changes the department staff had identified since the program had transferred to TDLR. And then we also updated the supervision provisions that were throughout the chapter. And those supervision changes had been worked up through a work group and then reviewed by the advisory board. So we kind of combined those to have one big package. The speech language pathologist and audiologist advisory board met on January 4th to discuss this big combined rule package, and they recommended publication in the Texas Register. It was published in the Texas Register on January 26, 2018, and the 30-day public comment period closed on February 26, 2018. We received comments from 3 interested parties, including 2 individuals in the Texas Speech Language Hearing Association. Again, you have copies of those public comments and the department's proposed responses to those comments. Based on the public comments we received in the discussion with the advisory board, and the advisory met on March 6 again, we have made some changes, some cleanup changes to rule sections, and I'll just read them off once and refer to them. It's sections 111.30B6, 111.35B3, 111.40B6, 111.40F, 111.45B3, 111.50B, 111.51G, 111.91F, and 111.154F4. A lot of those are cleanups and making sure we got
What was
the.
that fourth one? No, I'm just kidding.
So the advisory board had recommended that the commission adopt the rules as published with the changes that I just read, and I won't reread. And the commission, and the department is making the same recommendation that they adopt the proposed changes to the chapter 111 as with all the specific changes as referenced in your agenda caption, and then the specific rule changes since publication that I just referenced with the effective date of May 1st, 2018.
Any questions for Wendy, other than the one she didn't answer for me? Motion to be in order?
So moved.
We have a motion, second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item N, discussion and possible action on proposed amendments to the hearing instrument fitters and dispensers program. Commissioners, you also did receive, we received an email from the executive director of the Texas Hearing Aid Association, which I believe you have a letter. And you have a copy of that before you also. So, Wendy,
Thank you.
proceed.
Wendy Pella, Assistant General Counsel. These were proposed changes to the 16 Texas Administrative Code, Chapter 112. Again, there's a number of rule changes you can see from the agenda caption. And this is for the hearing instrument fitter and dispenser program. These changes are meant to implement House Bill 4007 and House Bill 1543, both from the 85th legislative session, and to make other cleanup changes. The hearing instrument fitters and dispensers advisory board met on January 10th, 2018 to discuss these changes. The board didn't make any changes to the proposed rules, but they did recommend that a work group be appointed to study Texas Occupations Code 402.251B as amended by House Bill 4007 and the proposed rules to 16 Texas Administrative Code Section 11250 regarding the subsequent temporary training permits that would be issued after the first one expires. We published the department published the rules in the Texas Register on February 9th, 2018, and the 30-day public comment period closed on March 12th, 2018. The department received 2 public comments during the comment period from the Texas Speech Language Hearing Association and the Texas Hearing Aid Association. And based on those public comments, the department is recommending withdraw rules 112.50, .52, and .53 regarding the temporary training permits. We propose withdrawing those from this rulemaking and proposing these changes to these sections in a future rulemaking that will just be about temporary training permits. The advisory board met on March 21st, 2018, and they also have the same recommendation as to withdraw those 3 rules and recommend that the commission adopt the rules with the exception of 112.50, .52, and 53. And again, you have copies of the public comments in your materials, the department's responses. We also, the Texas Hearing Aid Association also made a public comment during the advisory board meeting as well, and they referenced their their public comment letter and reiterated their concerns and their recommendations in that. So our recommendation to the commission would be to adopt the proposed rules as published with the exception of 112.50, .52, and 53, which are withdrawn, and the adopted rules would have an effective date of May 1st, 2018.
Any questions for Wendy? A motion to be in order?
Second.
We have a motion, second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Della.
Mr. Chairman, I don't know if you're aware that the Kansas Jayhawks, where Wendy Pillow graduated from, is going to the Final Four. I don't know if you're aware of that.
I was more aware that the Texas Tech Red Raiders made it to the Elite Eight.
They did a fantastic job.
That was probably more prevalent for me to be able to discuss than the Kansas Jayhawks at this point in time. So a little sensitive. So I appreciate you bringing that up.
Still raw. My evaluation's coming up, and I dropped the ball on that one.
I've been trying. It's all Big 12 at this point. We've got to stick with the Big 12. We're proud of the Elite Eight.
I
That's a
agree.
big deal.
I agree. I agree completely.
And I'm
you
sucking
get a
up
good
on behalf
you get
of
a
my
good
boss.
evaluation.
Yeah.
Yes, Wendy, of course, is a Kansas Jayhawk. So she was pretty proud yesterday, and she wasn't hooping and hollering, which I was hoping for, but that's not what happened. But
I don't think we're going to see that.
we are, just so you know, I myself will be rooting for the Jayhawks since they are in the Big 12, and we do have some connections here. So good luck to them, although I tell you, I'm thoroughly impressed by Loyola.
I was going to say.
Do people from Kansas hoot and holler?
Obviously not.
For basketball,
Kind of a
yeah.
Texas
Loyola
thing.
game. I mean, you talk about Cinderella.
But yes, good luck to you, and we'll be talking to you the next time, I'm sure. So if they win, we'll probably hear a hoot holler then. So, Della, my apologies, but we're talking about important stuff.
Good morning, Commissioners. Della Lindquist, Deputy General Counsel. In the 85th Legislature, House Bill 4007 made some changes to the massage therapy law.
My apologies, we are on item O, which is discuss possible action on amendments to massage therapy program.
Yes.
I failed to mention that, so please proceed.
House Bill 4007 made some changes to Chapter 455 Occupations Code, which is the massage therapy law. Primarily, they added the advisory board and clarified that everybody applying for a license now has a criminal background check. There were some kind of inconsistencies in the law. These rules were published on January 12th. Public comment closed February 12th. There were 7 interested parties that commented. However, there was no changes to the rules made based on those comments, and I believe you have them there in front of you. We were asking, the Massage Therapy Advisory Board did meet February 26th and recommended adopting these without changes. So we ask that you adopt these rules with an effective date of May 1st, 2018.
Any questions for Della? A motion to be in order?
So moved.
We have a motion. Did I hear second?
Second.
Second. My apologies. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you. Item P, discussion possible action of new rules for the behavioral analyst program.
Good morning, Commissioners. My name is Laura Pefferly. I'm with the General Counsel's Office, and I'm here to present the brand-new behavior analysis rules. The legislature in 2017 created the behavioral analysis program. That's in a new Occupations Code chapter 506, and the rules are going to be in 16 TAC, Chapter 121. The brand-new advisory board met for the first time on December 13th and voted to propose the rules at that meeting. They were published on February 2nd. The public comment period closed March 5th. There were comments from 19 individuals and 4 organizations, and the comments mainly focused on 2 areas, the fees and the scope of practice. The fee fiscal analysis was recalculated with some new figures, and so the fees were reduced from the originally proposed $390 to $165 for the behavior analyst, and from $330 to $110 for the assistant behavior analyst. So that addresses pretty much the fiscal analysis and fees issue. The scope of practice is something we're going to continue to work on. There are a number of comments about the scope between the behavior analysis professionals and the speech-language therapy professionals. TDLR regulates both of those professions, and there is some overlap, and so we're going to work on that. We already have some amendments to the behavior analysis rules started to address some of the issues that came up in the development of the rules. We wanted to get the rules adopted to get the program up and running, but there are some issues that the board identified and staff has identified, so we're going to work on those and address those scope issues. The board met on March 16th again and voted to send these rules to you for adoption, and we're recommending today, there were just a few minor wording changes in the rules from proposal to adoption, and so we're recommending today to adopt the proposed rules with changes to section 121.22, 121.70, 121.80, and 121.95 with an effective date of May 1st, 2018. They don't need to have a license until September 1st of 2018. So they'll have some lead time there to start applying for their licenses beginning in June.
Are we finding the scope of practice to be, for the health-related programs that have been brought over to us, to kind of have some semblance of order? I mean, or are they kind of all over the place?
Mr. Chairman, I would answer the question this way. We are quickly going into the world of scope of practice, and that by itself implies gray. You have work that can be done by speech-language pathologists. It's the perfect example. When you look at some of the comments that were received, you had some folks that were speech-language pathologists that are speaking about the work that a behavior analyst can do, and there is a crossing. There's some shared area. So it's not a clear linear line. Hearing instrument fitters and the audiologists have some crossover in the work they can do, and it's just something that we've inherited, and we're just going to have to be able to really be open to those conversations, be mindful about it. Philosophy on this side of the table is that we are not going to battle, we're not going to engage in scope of practice battles, but we are going to ensure that people who have a license can work clearly under the scope that's identified in their statute. And if the legislature has saw fit to identify that the scope of practice kind of grays over, and then so be it. I presented, and Laura and a number of our folks were at the conference for behavior analysts probably about 2 weekends ago, and I started off with that, just telling them how futile it is to joust over scope of battle practices. You have the authority to do it now. Don't spend time talking about someone who says, oh, you shouldn't be doing that. The law says you can do it. You don't have to wrestle with that anymore. That battle's been won. You've got that battle. So yeah, you're going to hear scope of practice quite a bit.
Would it be advantageous at some point in time to bring the behavioral analyst, the hearing fitters, audiologists together to discuss distinct separations and then common ground from a rural standpoint?
I think that family reunion could take place, but maybe after we get some traction.
No, I understand that,
Yeah,
but
yeah.
I'm just trying to figure out down the road if we
Yeah,
can find
it could be a possibility. And in fact, they're going to be together when we get into the strategic planning process. They are going to be
Right.
sitting in the same session, and they're going to hear one group say, we don't think that the so-and-so should be able to do X. And I will navigate that moment and say, all right, we'll put that on the board. Well, I think we should do X. So, I mean, we're going to
Okay, we'll put that on the
we're going to be dancing in that moment for a little while.
Okay. Which I believe strat planning is about to kick off.
Yes, sir.
And just kind of for informational purposes, I've assigned Commissioner or Vice Chairman Butler to head that up. So, I'm sorry. So we have a recommendation from General Counsel, and Laura to, well, you have it before you. So a motion would be in order?
Motion.
So moved. Second.
Your motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Mr. Chairman, Brian Francis, if I could commend Laura. I know she had a lot of help with a lot of the program and subject matter experts to build a set of rules from scratch, and the way that she did it. She did
Okay.
a fantastic job, so thank you, Laura.
Perfect. Thank you, Laura.
Really great.
Item Q, discussion possible action on proposed repeal of rules to the sanitarian program.
Mr. Chairman, Commissioners, Brad Bowman, General Counsel, and my comments are going to relate to actually the next 6 items. These are all very similar. They are cleanup from the Phase 2 of the programs that transferred over from the Department of State Health Services. As you recall, the Commission has already adopted new rules for all 6 of these programs that took effect November 1st of 2017. However, the old rules from the Department of State Health Services are still on the books, and so we need to go through as a cleanup and repeal those rules, and that's all we're doing here in these 6 items.
You want to just kind of discuss in general the repeal of those rules and any distinctions between them, and then I can probably rapidly just take each one up after that for the repeal.
Yes, sir.
Is that good?
Yes, sir, that works. And there, we published each repeal in the Texas Register, as we're required to do, for a 30-day public comment period, just like with any other rule proposal. We only received one comment on one of the rule proposals, and that was in the code enforcement officer's repeal.
Which is item R, Commissioner. Okay.
And that was just simply a comment thanking the department for the department's efforts during the transition of that program over from DSHS. Other than that, we received no comments, and so we would recommend adopting each of these repeals with an effective date of May 1st.
Commissioner, I'm going to take these up one by one, but I'll just kind of rapidly go through each one of these, and we'll get these 6 knocked out. Item Q, A motion would be in order to repeal the rules for the sanitarium program.
So moved.
Second.
We have a motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item R is a discuss and propose action to repeal the rules for the code enforcement officers program. A motion would be in order. We have a motion
Second.
second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item S, discuss and possible action of repealing the rules for the massage therapy program.
And a motion.
Second.
We have a motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item T, discuss and propose action on the repeal of the rules for hair laser removal program.
And a motion.
We have a
Second.
motion second. All in favor signify by saying aye.
Aye.
Motion carries. Item U, discuss possible action repeal of the rules for the mode assessors and remediators program. A motion be in order.
Motion.
Second.
We have a motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item V, discuss possible action on repealing the rules for the offender education program.
So moved.
We have a motion
Second.
second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you.
Thank you.
I believe that takes care of all the items that we need to vote on, right? Okay, let's go on to the staff reports. I'm sure that we could probably get this all cranked out within less than 10 minutes.
Yes, sir.
I told the commissioners we'd be out of here by noon.
It's going to go
No
down.
pressure.
It's going down. Mr. Chairman, Commissioners, I'm Brian Francis, Executive Director with TDLR, and we're going to give you some handouts real quickly. I just want to just briefly talk about the strategic planning process. Number one, this is my favorite time of the year. I love having the opportunity to meet with our staff, talk about what the future can look like. I love the opportunity to meet with our licensees and really have a very good, heartfelt conversation about what are the things that we're doing well, but also where are those areas that we can improve them. The staff knows the process, they know the drill. We're not afraid of the dissonance. We know that we can improve as an organization. We're going to hear things that could be a little bit off-putting. You know, you need to do a better job on X, but there's going to be truth in those statements. We've provided information in the commission portal that lays out the strategic planning timeline. We've included the instructions from the Governor's Office of the Legislative Budget Board, and we've also included information about the specific locations for the external focus group sessions that we'll do on the 9th, the 16th, and the 23rd.
And I would encourage commissioners, if you're near one of those areas, to
Absolutely.
just kind of look at the dates. They're out on the website, also on the commissioner's portal, and try to attend one of those meetings.
So the 9th, 16th, and 23rd is what you said?
Yes, sir. When you look on that first page, the 9th, we will be in Arlington and El Paso. On the 16th, we'll be in Houston and McAllen. And on the 23rd, we'll be here in Austin. We'll start having internal focus group sessions as early as tomorrow. I'll be leading a couple with a cross-divisional and functional group of employees as we go forward. The big dates that I'll point your attention to on the timeline is if you look at the top of the second page in this document here, we've got the instructions and our due date's pretty tight. But we're going to get a lot of great information going through it. We're going to put a lot of work on the commissioners on the early part of May and get us ready to make a decision on May 24th for adopting our strategic plan. You may recall that they made dramatic changes to the instructions last time. They narrowed down the number of pages. They also kind of guide you into the information that should be included in there. We're going to do our TDLR look. We're going to have, the big picture. I don't anticipate that we'll have as many strategic initiatives. Remember, we went in the last session with 56 and had a 93% pass rate of 52 of them being passed. That was super aggressive. The staff has still, been flattening my tires from that last time around, but I think I'm going to keep some air in them this time. We're really going to hit those high-button issues that need to happen. The big picture stuff, those impediments, if there are any deregulations that come out of the conversation, those are the things I think really need to be focused on this go-around. We've done the cleanup stuff. We've tightened up the rules and those sort of things. So commissioners, we'll be reaching out to the work group. We've already provided them this information prior to the meeting today. We'll have our first huddle, I believe, on May 14th, and I'll probably do one actually after we complete the external focus groups, just to give a sense and a flavor of the comments that we're hearing coming out of those sessions. On April 5th, this is the last thing I'll point out, Mr. Chairman, we're doing two roundtables, one with executive directors for the various associations. We've invited the full cross-section section of our associations to come here. I think the EDs obviously represent those industries, but there's a different seat that they hold that they can provide us information about the rulemaking process and some of the administrative stuff as it relates to communicating with their industries. And then we'll have one with some of the policy experts to give us a sense of what do they think is going to happen next session and what do they think the role of government should be and licensing should be. Those are conversations that we need to have. They're taking place. We just want to be in the middle of those and make sure that we're aware of those conversations. This is an exciting time. I know that this is Nick and Carla's first strategic planning session here at the agency. It's not their first rodeo in doing strategic planning, but just the way that we do it here at TDLR. And so they're going to be immersed in it as well. So very excited about this opportunity.
They'll find out how it's done correctly. That's what you're saying.
They are going to allow us, like they've been doing, to improve all of our processes and make them better.
Good follow-up.
Thank you, sir.
Any questions for our executive director? I think as we go through this strat planning, as we've done in the past, of course, is to ensure that there are programs that need to be deregulated. Also, let's make sure that we're addressing maybe issues of barriers to entry and how we can clean that up also, and make sure that we're continuing to follow the lead of the governor's office in ensuring a prosperous economic development in the state of Texas. So I think it's important that we do that. So, I guess you won't have anybody else on up to bat for staff reports?
Yeah, we would definitely wanted the time to be dedicated to strategic planning on that.
Perfect. I would make note that I believe that all the commissioners received a new organizational chart.
Yes, sir, the calibration.
The calibration, I believe. And so you would make note of the new program. The Regulatory Program Management Division now has also reporting with us for. Let's go on to the advisory board reports. You have that information before you. I don't know if there's anything to report there.
Mr. Chairman, the fruits of their labor were actually reflected in the rulemaking that the commission just adopted.
Perfect. Item Y, let's go on to the discussion of our meetings. Currently, our next meeting is scheduled for Thursday, May 24th. We've moved it from Friday to Thursday to coincide with Memorial Day, I believe. That's what we run into a problem there. So we moved it up. After that, our next meeting is July the 20th, Friday, July 20th. We have suggested dates of September 7th or September 14th. Those are both on a Friday. I don't know if any one is better for the other, September 4th or September 7th.
Do the 7th, sooner than better.
So we're good?
Yeah. When's Labor Day?
Labor Day is 3rd.
I'm sorry?
3rd?
Well, yeah, September 3rd.
Okay, 7th would work for me.
September 7th? Okay. Let's go ahead and put in pen, September 7th. The next meeting date is suggested October the 12th or October the 19th. That's also a Friday. Any day work better than the other? I would recommend, probably since we're having the meeting on the 7th, maybe we look at the 19th. That pushes it off another week or so to be able to collect additional cases and motions for rehearing. So if you're okay with that, let's go ahead and put down October the 19th. Okay, if you don't mind, let's make sure that we pass this information on to Dr. Callis, who needs as much lead time because of something about his practice or something, I'm not sure. So, okay, so we're scheduled now for Thursday, May 24th, Friday, July 20th, Friday, September 7th, Friday, October 19th. And in our May meeting, we'll go ahead and fill out the rest of the year at that point in time if we have any other dates that need to be taken a look at. I do want to address, and I appreciate Commissioner Butler mentioning it to me, my Vice Chair Butler. Commissioners, you received an email relating to customer service and issues that we're having there. I just want you to know I've instructed the Executive Director to begin to start taking a look at that issue. He's brought forward everybody to begin to start addressing that to make sure that we are addressing those issues. They're also working on some reports for us to be able to take a look at that relate to number of calls, number of hold times, the time of the hold, and a time of calls, because we want to make sure that we're always providing customer service to the citizens of Texas. And if we have something that comes before us, which we have, someone that brought to our attention, then we want to make sure we're addressing it. So I want to let you know that we are addressing it, and we're working with the executive director and his staff. He's kind of taking the lead on that, but we want to make sure that we're getting that addressed, and so just rest assured that we are. So,
Thank you.
all right. There being no further business, it's exactly 5 minutes till 12. So, meeting's adjourned.